We'll resume, we'll start the Stream 6 hearing. This is about designations. Commissioner McMahon and I are in charge of this one. We have, do we have anybody on board? No. So, Mr. Smeaton, we've read your 42A report and the supplementary report. Thank you for undertaking that analysis of the Wakakatahi conditions that I asked for. That's much appreciated. Makes it a lot easier to see what we're talking about, and hopefully it will have assisted the Residents Association. Well, what would you like to say to us before we start?
Good morning, and thank you. I've just got some very brief notes I thought we'd just run through very quickly just to introduce things, and then we can go from there. So, again, my full name is Rory McLaren Smeaton. I'm employed as a Senior Policy Planner here at the Council. Today my evidence relates to the matters in the designations chapters, and I'm authorised to provide this evidence on behalf of Council. Appendix E of my Section 42A report sets out my qualifications and experience, and I confirm that I am continuing to abide by the Code of Conduct for Expert Witnesses set out in the Environment Court's Practice Note 2014. So just very briefly, for this introduction, I'll just briefly speak to my Section 42A report, my supplementary evidence, and the tabled statements from submitters. So my Section 42A report addressed assessment of the designations under Clause 9 of Schedule 1 in Sections 171 and 168A of the RMA, as well as submissions and further submissions received on the designations chapters. There are approximately 21 submissions and 4 further submissions received on the designations chapters. The key issues raised through submissions and addressed in my Section 42A report were conditions on FGL 01 and the rollover conditions for NZTA 01. I've also recommended amendments to the following chapters relating to the Chorus, First Gas, Kiwi Rail, Minister of Education, New Zealand Transport Agency, and Spark, New Zealand Trading Limited. I'll take my Section 42A as read, as you've already noted, and I'll invite any questions from the panel on the contents of that report. I think I'll just carry on.
Yep, keep rolling.
So my supplementary planning evidence addressed the following matters: Wakakatahi designation conditions, amendment to the requiring authority for NJUS-01, amendment to my recommendation for FGL 01, and clarification of my recommendation for KRH 01. Again, I'll take that evidence as read, and I'll just move on to the relevant tabled statements. While not addressed in my supplementary planning evidence, I'm just noting that I also read the submitted statements from Chorus New Zealand and Spark New Zealand Trading Limited, Ministry of Education and Transpower. I note that these requiring authorities accepted my recommendations on the respective designations, including any relevant amendments that I recommended. So on that brief sort of introduction, I'll hand over to you for any questions on my Section 42.
Thank you. For the benefit of my colleague, I think we'll do this 42A report section by section, and then move into the supplementary evidence. So basically interrupt me if you've got anything. My first question was in relation to the statutory considerations. Given the paucity of the submissions, what jurisdiction do we have to recommend changes of designation if no submission actually sought changes?
Well, as I read it, Clause 9, Subclause 3, related to rollover designations, where no submissions had been received and no changes were recommended by the requiring authority. No modifications, sorry.
Yeah.
So as all of the chapters had some submission made on them, although in most cases they were from Kāinga Ora seeking retention of those chapters. In my mind, it didn't meet that requirement under Clause 9.3, and the Clause 9.1 and 2 also require assessment of those designations under Section 171 and 168A.
I suppose the point being we have to consider them, but what jurisdiction do we have to modify them if no submission sought modification, and KO's, Kāinga Ora's submission is the only submission?
It's an important point because, I mean, what we're trying to ascertain is whether there's a difference between scope to make changes to the designations compared to scope to make changes to the district plan. Because really the designation process is a cutout of the district plan process. I presume through you, Mr. Chair, that there's nothing to stop recommendations and decisions on designations being decided and sent out separately to the district plan process.
No, and as I understand it, it just runs in parallel to the district plan process. Essentially, from this point, it runs very similar to a normal designation process where the recommendation is sent to the requiring authority and they can accept or reject that.
Yes, although some of the matters will be decisions, won't they, for a local authority designate?
Correct. If it's under 168A, it will be a decision for the council, yes.
But won't it also be a decision under Clause 9 for rollovers of local authority designations?
Yes, so where it's a
Yes.
PCC designation,
Yes.
yes, and it's been rolled over, yes, it'll be a decision on
Yes.
that
Yeah.
designation.
So the issue, I'm not trying to overcomplicate this and hijack the chair's question, but there's with district plan provisions generally, there's the ability to make changes are limited by scope of submission. So what we're trying to ascertain is there a difference here with designations? I mean, if the panel for whatever reason had a concern with a particular designation or a condition and there wasn't a submission relating to that concern, are we constrained in our recommendation and decision, depending on who the requiring authority is, as to what decision or recommendation we make?
I don't believe so, and that's why I have recommended some changes to some of those designations. So that goes back to what I was saying before, where I think that that clause 9.3 is the constraint.
Yes.
If it was rolled over with no modifications and no submissions on it, then I think the recommendation would be constrained, or there would be no recommendation. It would just be rolled over into the new PDP.
And just on that, 9.3 just refers solely to whether there's been a submission and not whether there's a submission in opposition, presumably.
Correct, yep.
Yes.
So I've set that out in paragraph 28 of my...
Because otherwise, had it not been for the Kāinga Ora submission, those designations would be deemed to be included in the district plan, presumably under 9.3.
I believe so, essentially, yes.
Okay.
So it does, at the end of that clause it says, and on which no submissions are received. So it doesn't say whether or not it's in opposition or...
Yeah.
And I think we can assume from the fact that the relevant requiring authorities have lined up to agree with your recommendations, rather than to say you had no jurisdiction to make recommendations anyway, that they agree with your analysis.
I presume so, yes.
Okay. Anything else, Mr. McMahon, on the sections 1 and 2 before we go into the content?
Yeah, I had a more generic question through you.
Yes, just roll.
Yes. I guess I was a little bit intrigued, Mr. Smeaton, that there'd been so little activity on this on the matter of designations, and I just wondered whether you were able to shine a light on why that might be. I mean, were you were you involved in the original instigation of the call for rollovers of designations, etc.? And did you have any dealings with requiring authorities in that period?
No, so I wasn't involved in that stage. I wasn't at council when that initial notice went out for requiring authorities to notify the council on any rollover or new designations.
Okay.
But I presume, as I've set out in my report, I think 70 of the 81 are essentially rollover designations. Of the 11 that are new, most of them are existing activities, like the schools or the telecommunication facilities.
Yes.
The effect of the designation, or on the environment at least, is very small. So the more contentious issues are, as I've sort of set out in my report, relating to the new first gas, where there was submission. So I think that probably explains why there is sort of very little submissions.
I don't want to be seen to be jumping at shadows, but I was, with designations, in my experience, there's usually been two issues. One has been with the notation of the designation, which sometimes is sought to be broadened or made more specific through the modifications of requiring authorities. And the second is with conditions. And there seemed to have been a move since the Devonport case, which was a defence case back in the 90s, which sought a move away from generic type designations, like in that case defence purposes, to notations that more precisely describe the activity, and so that the people reading the plan might have a better understanding of that. On that matter, and notwithstanding the absence of submissions, have you looked at the designation notations for the 12 requiring authorities to ascertain, in your view, whether they're fit for purpose?
When I was looking at the doing my assessment for the Section 42A, I did look at the notations within the plan, and I did note in the rollover of that majority of those designations in the PDP, there have been small changes to the notation to comply with the national planning standards. Within the operative district plan, the purpose of the designations isn't entirely clear. It sort of sits within a text above the table, and normally it just refers to whatever the purpose of the requiring authority, I think, had in their Gazette notice.
Well, let's just have a look at a couple of examples then to help, though. So, and I'm not picking on any requiring authority here, for let the record show, but education purposes is a common one for the Minister of Education. So that could cover a wide realm of primary, tertiary, secondary, and perhaps preschool purposes. So had you considered whether that designation was sufficient to allow for preschool facilities to establish on primary school sites and the potential effects of that?
Yes, so on that exact one, the Minister for Education also included essentially a definition of education purposes, which sits in the additional information for those designations. So that specifies quite clearly
Can you point us to that? Is it in your 42, or is it in?
I don't think it's in the 42.
Go to page 8 of the schedule, Commissioner. There's an
Page 8?
Page 8 of the schedule.
Yes, I have that.
Oh, yes.
Yes. So that would include any preschool. Okay. So could a private provider of preschool facilities take advantage of that designation once it's operative?
I wouldn't believe so, because they're not the requiring authority that has the benefit of that designation.
But they could be the requiring authority's agent. Depends on the relationship between the ministry and the private provider.
Yes, that's true, and that might be akin to the other designations that have been included in there for state integrated schools.
Yes. I guess, how many primary school sites are there? I mean,
I'm not exactly sure. I think there was somewhere around 28.
Okay, no, that's good to just get the rough idea of quantum. And one new one that's being the Bishop Yard College, is that correct?
I think there were four
New ones.
4 or 5 new
Okay,
ones.
yes. So that education purposes designation would apply to all 28.
All of the schools, yes.
So how would if there was a new development on a school site, let's say a preschool facility that was where the minister had financial responsibility for the work, the bulk and location aspects of that would be handled through an outline plan process.
Yes.
And under Section 176A. One of the key issues with preschools is noise and traffic drop-offs, those sort of things. How would they be dealt with under the outline plan, as in the absence of any conditions dealing with those that frame the envelope of the designation?
I believe under that section for the outline plan, there is also the clause which relates to any other mitigation of adverse effects on the environment. So I think it would come under that. If I was to prepare an outline plan for that sort of matter, I would address the noise aspect of that.
Yes. Again, this is just a theoretical question. You didn't think there was a need to prescribe as a condition of the designation noise standards that equate to the underlying zone for the school that's affected by the designation?
No, certainly I didn't when I was preparing my Section 42 report, and I wouldn't think that that's necessary, as we've got specific noise standards for each zone in the PDP. In preparing an outline plan, you would normally take that into consideration.
Yes, but you accept, Mrs. Meaton, that the designation suppresses the underlying zone and overrides the standards such as noise standards.
Yes, I do. I think I'm still not of a mind that would be entirely necessary, because an outline plan would need to take that into consideration.
If the council, in assessing the outline plan, wanted to impose noise restrictions, how would they do that on a particular outline plan, particular development? Let's say it's a significant preschool facility on an area that's closely, a surplus piece of land, playground or something, most likely bordered by residences, given that most of the schools are in residential zones.
I don't think there would be an ability to put in or impose conditions per se. The council would be able to request that additional mitigation be imposed through the outline plan. But that would be, I think, the extent of the ability of the council to influence that.
And similarly with any mitigation that's required in relation to, say, traffic access or drop-off points. I'm not talking about car parking, but quite often with preschools, there's I think best practice is having circular drop-off arrangements so that there's a separate ingress and egress for parents dropping children. How would that be handled in a similar way?
The same way, I believe, yes, through the outline plan process,
Yes.
the council will be able to request amendments.
Yes, and you appreciate that the council can only recommend alterations to the outline plan. Yeah, and they recommend back to the requiring authority who makes the final decision.
Yes, and I believe if the requiring authority does not accept those, then that can be elevated to Environment Court, but that's the...
By appeal by the council.
yes.
Yes, and there's no provision for third-party involvement in outline plan processing. No mandatory provision.
No.
Okay. I mean, these may not be issues, Mr. Meaden, but I'm just wondering whether they were on the agenda of the council. Have you had any opportunity to discuss outline plan processing with the consenting staff of the Porirua City in terms of whether there's been any issues with outline plans or any issues with designations generally over the previous planning period?
No, I haven't discussed that directly with the resource consents team. I have been involved myself in processing some outline plans or a outline plan and designation. So I don't think they're particularly common within Porirua, but that they do come in from time to time.
Okay.
I had a follow-up question in that regard. Can you tell us what Porirua past practice has been? Has it in fact recommended additional mitigation?
On outline plans that have been processed?
Yes.
Yes. On a recent one, yes, I had recommended an amendment. I'm not sure of the long term how often that is the case, but certainly in recent times.
And who was the requiring authority? Doesn't matter.
I think
if you can't recall. I'm more interested in whether the requiring authority, whoever they are, actually accepted the recommendation.
I think in that case it was through an agent, but it was actually the council as the requiring authority. So,
So you would hope they you would hope they accept it, but you don't know.
No, that was accepted. Yes.
Yes. I just want to carry on that theme a little bit more. I don't want to prolong it, but let's just have a look at, again, I'm not picking on anyone, Chorus New Zealand. Several telephone exchanges proposed to be designated. I think all of them rolled over, I think. Might have been one new designation, maybe. Yes, I think for the Tatahi Bay Exchange, might have been a new one. But anyway, that's not my question. The designation purpose in that instance is telecommunication and radio communication and ancillary purposes. And I'm very familiar with this notation. It's that and aspects of it have been used around the country. It draws on, well, can you tell me what definition or assistance it draws on in the plan? If any.
It does integrate, I guess, or draw on the regionally significant infrastructure definition, which is included within the plan to give effect to the RPS definition.
There's no definition of telecommunication and radio communication purposes in the plan under utilities chapter.
I can't recall.
Yeah. Could you come back to us on that?
Yeah, sure.
That would be. The term ancillary purposes is one that's created a bit of concern around the country as to what it actually means. And I think there's been quite a bit of case law on this, not just in relation to telecommunication matters, but ancillary purposes generally. What's your understanding of that, what that would mean in in the context of this designation?
I believe actually within the PDP we do have a definition for ancillary purposes.
Okay.
So it would.
Can you
fall under that.
bring that up? And
I can. So within the within the PDP, it's actually draws on the National Planning Standards definition for ancillary activity. So it's slightly different, but means an activity that supports and is subsidiary to a primary activity. So it's quite broad, I suppose.
so what might that be on a telephone exchange site, do you think?
Well, within those sites that have been designated through this process, I believe they have ancillary activities such as ancillary power backup generators, generators, which I would consider to be an ancillary activity.
Yes. So that might include an ancillary, power generation backup for purposes other than emergencies, such as load sharing.
Correct.
Yes, which could operate more regularly than in emergency situations, which could have a noise instance. Most telephone exchanges would be in residential or semi-residential type zones, I imagine.
Yes, that's true, and I do take your point. It would certainly or likely be more common than just emergency purposes.
Yes.
For these sites, they are existing sites,
Yes.
currently relying on existing use rights. So in terms of the effect on the environment, I think it's negligible. But
but I'm
if it
thinking
was
more
new-
of new development on these sites. I mean, it's one thing to say that these sites have been dormant and any new development would, again, have to go through the outline plan.
Yes.
Council would have to be clear that the activity and the components of the activity fitted within the designation purpose. And then they would assess the outline plan. And same issue with schools. Any noise concerns, any proximity to boundary concerns, any visual impact concerns, any traffic concerns would have to be handled through the outline plan process.
Correct.
Yeah. Okay. One of the issues that's come up with these designations around the country is the issue of cell site development on telephone exchanges, and in Christchurch during the early part of the 21st century, there were significant appeals on telecom designations throughout the city. Looking at that issue in particular, have you given any consideration to whether that raises any issues with the designation purpose or the absence of any bulk and location standards as conditions on those designations?
To be honest, it wasn't something I particularly turned my mind to very much, other than I believe on one of the sites that has been sought to be designated, there is an existing cell site on it. But yeah, I didn't particularly to my mind to any requirements for any conditions to mitigate any development such as that on the sites.
One of the issues, aside from the bulk and location aspects of cell sites, and has been the issue of RF radio frequency emission, and there's a narrow New Zealand and Australian joint standard on that, NZS 2771, I think it is, and I think that's now part of the NES on telecommunication facilities. I guess my question there is, can the council rely on that NES and its reference to the Australia-New Zealand standard, or does the designation have the effect of, underlying zonings, overriding that provision in terms of control of RF emissions?
No, so to my understanding, where there is an existing NES in place, a new designation would not override that. So I've actually set that out in parts of my report, but in relation to the National Environmental Standard for Contaminants in Soil, rather than the telecommunication NES specifically, but I believe it's testing my memory, but section 43D, one of the clauses in there which sets out the relationship between a new designation and existing NES.
Yes, that's 43D of the RMA.
Yes,
Right.
I can double check.
That would be useful.
What was that section, sorry? 43?
Sorry, I'll just double check where I've put it into my report. So in under the section 3.3 of my report, which relates to the Chorus New Zealand Limited designations,
Which page is that, Mr.
page 11, paragraph 71. Section 43D,
Yes.
subsection 4 of the RMA.
Okay, so that was in relation to the contamination NES, but you're saying
Yes.
that applies to all NESs?
Yes, in my understanding, yeah, it sets out the relationship between existing NES
Okay.
and a new designation.
Yes. Mr. Smeaton, I wondered if, let's just assume for a moment scope exists, and it might even be a clause 16 matter. I wonder, just looking at the beginning of the designation section, and on page 2 of the track changes on Appendix A, and it has some introductory provisions there about designations, when they take effect, and what is a designation. And it makes reference to that the designation doesn't preclude the need for any regional consents that might be necessary. I wonder whether it might be useful to the plan reader to also make some reference to the obligations under NESs. I don't think it adds any, it's as an advice note type, it doesn't add any new requirement, it just makes it clear. How would you feel about making that alteration?
I'd be quite comfortable with that, and I think it would be a useful addition to that
Yes.
introductory section. And as you can already see there, of under section 16, I've already recommended removing that
Overview.
superfluous
Yes.
information.
Okay.
Just while we're on that, I've pulled up 43D4. It says a national environmental standard that exists when a designation is made prevails over the designation. How do you interpret that in relation to a rolled over designation? Is that made when you have a new plan?
My assumption was that if it's a rolled over designation, then the NES would not prevail. So that clause would not kick in, so to speak.
Well, that would mean that 70 of the 81 designations.
Correct. And I presume the assumption is that if that would have been taken into account at the time the designation was made, to use that term. But for any new designation, the NES will prevail.
But taking the NES on telecommunication facilities and the reference to the New Zealand Australian Standard on RF emission, that's not the case with all the telephone exchange designate.
No, so I think there's one existing, and I think there was 4 new
Yes.
ones.
The one existing presumably didn't have a condition requiring compliance with the New Zealand Standard.
No, I don't believe there are any conditions.
Yeah.
In terms of the advice note, then, that you're discussing with the Commissioner, it would have to be specific to the new designations. And I was thinking that there is at least the theoretical chance that some subset of the 71 existing ones were made after the relevant NES was put in place. Probably unlikely because they haven't, because those NESs generally are not that old. But there's at least that possibility.
I believe there would be, thinking specifically about the NES for contaminants in soil, there would be at least 1 or 2 that have been since then.
It may be that any addition under clause 16 is written in a more generic sense, so that it just talks about the potential applicability of NESs without distinguishing between the existing and the new. So just as a sort of a roadmap for parties to check that.
It's sort of think about this
Yes.
type note.
Yes.
Yes, I can certainly think about
Yeah.
wording for that to
Yeah.
be generic enough.
Yeah, because it just surprised. I mean, I'm aware of this. I'm aware that there's been different interpretations on the provision of clause D, not clause D, subclause D of 43, and not all requiring authorities are on the same page as to what it's saying. And you haven't taken any legal advice on it, have you?
No, I have
No.
not.
And in the absence of that, I think it might be better that any advice note is in the general as opposed to the specific in terms of which designations it may or may not apply to, and then the law can then take effect.
On the basis that this would necessarily have to be a section 16, a clause 16 amendment. Probably better that rather than that way talking about potential applicability rather than staking out a position that someone may argue with.
Yes, I agree.
That was all from me on that largely generic type topic.
In relation to potential helpful notes, I was reading your discussion about Wakatahi general submission in 3.2, saying, well, good idea, but the national planning standards prescribe how you do this. But saying that there is actually a mechanism alternative, which I have to confess that I was oblivious to. So I followed my way through the website and found those existing, those alternative sets of maps. And I wonder, in the same way as the Commissioner suggested, that there would be merit in noting that at the front of the designation section as well, that there is an alternative set of maps that may be of assistance when distinguishing between overlapping designations. Because there's not much use if nobody knows that they exist. Because I was oblivious to this until you told us.
I think I'd be a little bit hesitant, just because I know council websites can change somewhat over time, and whether putting that into the plan itself might be a little bit risky. But
I wonder whether then, rather than saying that they exist and pointing the reader to them, suggesting that if you're having difficulty distinguishing because of the way they're doing it, contact the council staff.
I think that would be a useful note, and because I think council could assist in a number of ways, including the fact that we have GIS data that is available to download as well, which I think most requiring authorities would be able to use.
Look, going to chorus, paragraph 62, you're talking about the objectives of the requiring authority. Where are those objectives to be found?
Well, it should be in the notice of requirement.
Yes, I went looking for that. And because the standard form doesn't actually require the requiring authority to specify their objectives, whereas, like, that's obviously, and particularly for the rolled over ones, whereas that's obviously a critical issue for new designations because they're assessed relative to it, where the necessity and consideration of alternatives are assessed relative to those objectives. So, so I think it was Wakakatahi have a clear section stating the objectives, the relevant designations, but not others.
Yes.
So I was wondering where, as I say, where you got that from.
Well, I know, so in the new one, there is a clearer statement of the objectives for chorus for those designations.
And did you assume that the new one applied to the rolled over ones?
Correct, I believe so. I'm just trying to remember whether they had anything specific or in their communications for the rollover designations where they notified the council that they wished it to be rolled over, which is
I wonder if I could ask you to check that. Also on chorus, talking about conditions, paragraph 77, you've noted the relevance of the notable trees notation. Can I assume that for all of these designations that was part of your modus operandi, that you checked if there were any relevant overlays for each one?
Correct. That was, yes, and part of my assessment for all of the designations was to look at the planning maps to identify whether there was any overlays, look at the relevant zoning, etc. In some cases, for this specific one, obviously recommended, pardon me, some conditions relating to that overlay. In other ones, depending on the overlay, for example, the Plymouth Schools site, which has a little bit of flooding overlay, and there's also the State Highway Noise Corridor. I didn't consider that any additional conditions were required. So, yes, I did look at that and made a determination in my recommendations as to whether any additional conditions were required.
Thank you. And going to first gas, 3.4, addressing Mr. McGavin's submissions, just as a matter of background, do designations create any right of access to the designated land?
No, I don't believe so.
So that might be a simpler answer to Mr. McGavin's concern. That the designation has no right, creates no rights,
Yes,
because it's the exercise of rights of access that he's worried about.
yes, it probably would have been good for me to point that out.
Paragraph 96 talk about venting and flaring, talking about visual and noise effects being identified by first gas. I wondered about hazard risk.
I believe that would be addressed through other legislation, primarily the Has No Act and the Health and Safety at Work Act.
The reason I ask is because there is a very extensive examination of the interrelationship between HASNO, health and safety, and the RMA in the context of the provisions in the South Taranaki District Plan governing the oil industry, where the Environment Court basically found, as I understand it, that there was a meaningful role for the RMA to deal with hazard risk from oil institutions, oil and gas institutions, or not institutions, but facilities. So I wondered if you'd considered that.
No, I'd have to look at.
Well, don't reach for it then. Can I ask you to consider that as part of your reply? I was intrigued by the statement at your 101, or recording first gas position, that the network generally complies with district plan noise standards. Which raises the question about, well, what about when it doesn't?
Yes, I did. I did note that, when I was preparing the report itself, and the conclusion I came to was that I've recommended conditions specific to construction management, or should address any construction noise and the operational noise as part of the existing environment for which the gas pipeline has existing use rights.
The talking about your methodology now, in first gas, you've specifically required conditions around effects for the first gas pipeline or designation, and you discussed that at paragraph 114. Can you expand on the reason? And here you're saying, well, you need more certainty than the outline plan provides. Basically, the question is, can you expand on your reasoning as to what are the significant differences? Why is the outline plan sufficient in some cases, but not in this one?
I came to the conclusion that additional conditions were required primarily because of the large geographic extent that the pipeline traverses through and the identified areas that have particular characteristics which are identified by overlays that require protection. So I've identified through that mapping that the pipeline traverses through areas of sites and areas of significance to Māori, statutory acknowledgement areas, special amenity landscapes. So there's a variety of those areas, and the particular characteristics of the activities that could be undertaken under the designation, which would include excavation and possibly quite large construction type activities. So it was the scale of the activities themselves and the sensitivity of the receiving environment as well that led me to require some conditions to mitigate the potential effects of those.
Thank you. As regards you can talk about construction effects, looking at your drafting, at page 5, you're talking about requiring submission of a CEMP. Is there any condition requiring that the CEMP, once certified, is complied with? And if there isn't, do you think that would be a good idea?
No, I believe you're correct. There isn't a corresponding condition for compliance with the CEMP, and yes, I'd agree that that would be, for certainty, that would be complied with. It would be good to include such a condition.
As regards your reasoning at paragraph 133, I'll talk to the first gas representatives at the moment, but can you clarify for me, does the designation exactly parallel the geographical extent of the easement?
Yes, so I believe it essentially overlies the easement, so they are both 6 metres on either side of the pipeline.
And I can imagine that the designation provides a benefit in terms of authorising activities within the easement area that the easement doesn't provide. Would those activities otherwise require a consent, or are they permitted activities?
think it would depend on the specifics of the site. In some cases, they may be where it's outside of any overlays, and depending on the depth of any pipe. I'm having to draw on my memory of the infrastructure chapter.
I don't remember
rules,
it, so I'm
yeah.
relying on you.
So within that chapter, there is a rule for underground for maintenance and of underground infrastructure, which references the standards for earthworks, where there's a 1.5 metre depth limit for any earthworks. There's also a specific rule for the gas transmission pipeline, which would relate to any new pipelines, which is it's from memory, a restricted discretionary activity as the activity status.
But given that it's sitting in the middle of a corridor where there is an existing pipeline, it's hard to imagine there would be any new ones within the designation.
Oh, I would believe so, yeah.
But is the better answer in terms of, the merits of, or the need for the designation, that it's not permitted, it's clearly not permitted in some locations,
Sorry,
and it's not a permitted activity in some locations of the corridor.
yes, yep.
And there might even be quite large parts of the corridor.
Yes. I think one of the constraints would be any, if the designation was not there, any activity within a significant natural area would be a discretionary activity, which in some cases is quite large lengths of where the pipeline runs through, and depending on what areas they wish to work on or maintain, it could be captured by that rule.
The next question, about your paragraph 156. You talk about a designation or overlap with K1047. What is that?
K1047 was another designation within the operative district plan.
Yeah, but what does it relate to? Whose designation is it, and for what?
Apologies, I didn't specify that in my report. I believe it's PCC's designation for a local road in that area. So as I have included in my report, it's in the location of Redoubt Lane. So it's a reasonably small designated area which covers that lane, which is a local road, and some parts adjacent to the railway. But I can provide the information from the ODP if that's...
The thing I'm really interested in, and I'll explore this in relation to the interface between the Waka-Kotahi and Kiwi Rail designation, is that you've recommended that the designation identify that the hierarchy varies. Which is the primary designation?
Yes, this is something Well, it's a little bit difficult because the national planning standards state that you can either put in the notation for the designation primary, secondary, or varies. For this particular one, I think it might depend somewhat on the location within the designation itself. I'm sorry, I can't recall exactly if they overlap exactly, or if only they partially overlap. So I think if it's within the road part of that designation, then the K1047 would probably be the primary. Whereas if it's within or closer to the railway, it might be the railway, but I'd have to just double check on the geographic extent of those designations.
Now, accepting that this is an area where the national planning standards are mandatory, as I say, it comes into sharper focus for the Kiwi Rail and Waka Kotahi designation, because Kiwi Rail say they're happy for the designation to be shown, Waka Kotahi's designation to overlap, provided theirs remains the primary one, which you could understand. If the plan says, quote, varies, how is it, where and how does anyone know which is the primary one?
And I assume you mean in certain, in certain locations where those overlap.
They overlap.
I have thought about this to some degree, whether it could specify within that box itself as to where it is primary or secondary. Another option is within the additional information part of the designation table. It could specify in there. I haven't recommended that be included through my report, but it could be something to think about further.
I could imagine that Kiwi Rail might get quite excited if the effect of allowing Waka Kotahi's designation to overlap theirs is that all of their designations are described as varying as opposed to primary.
Yes, it's. I think it's a particular an example where the national planning standards, where the intention is good. In practice, it's a little bit hard to use in some respects.
Well, I think I accept. I understand why you've recommended what you've recommended, but do you think there is a need to say somewhere?
Yes. Well,
which is
as you've raised, yes, that overlap on the railway land, which I've now accepted through my supplementary planning evidence, makes it a little bit more difficult, because otherwise you may have been able to say that one was primary. So I think it would be beneficial to explain it a bit further, and I think the additional information part of that table would be probably a good place for that to go.
Yes, I don't think it much matters where it is, as long as it's on the face of the plan. My instinctive reaction is that it's undesirable that it's somewhere in the council records, and particularly like for the one we started with, you would assume that the Natural Gas Corporation dug a hole in the council's road rather than the council putting a road over the top of the pipeline. But that may or may not be the case. But so so we'll leave that one with you to think further. Next point, figure 7. I just want to make sure I've understood this correctly. The bit that you're proposing be deleted is this triangle here.
Correct. Yes. So the as the KiwiRail tabled statement correctly pointed out, I should have probably said that
Not deleted, but modified.
modified so that the designation is aligned with the territorial authority boundary.
That's the KiwiRail one. Going on to Ministry of Education.
I'm not really coming in until the conditions.
Fine. All right, I'll just keep rolling then. The your discussion about at 193 about the integration agreements. Do those agreements give, or the legislation under which they're entered into, do they give the Ministry of Education any property rights over the integrated schools?
I'm a little bit hesitant to answer. It's slightly outside of my sort of area of expertise in terms of it's a slightly sort of legal question, I suppose. But from what I understand, it does give some financial responsibility to the Minister of Education.
So, the thing that was intriguing me is the precondition for not needing to consider alternatives is a sufficient interest in the land and the effects being more than minor. But the question is, does the ministry have any interest in the land? Like maybe you could still conclude that the effects are minor, but
I think I'd probably have to seek some legal advice on that, whether the integration agreement forms an interest in the land for that purpose.
I think, well, in terms of the robustness of your analysis and therefore the robustness of our recommendations relying on your analysis, I think that would be a good idea, because if the answer is that it's not, that it doesn't create an interest in land, and that if there is any issue about the level of effects, that would suggest that you need to give more thought to alternatives, and maybe you end up in the same place. But I think in terms of the robustness of your analysis, that would be a a gap.
Yeah, so I do note that he'd covered it off. Well, I'll certainly do that. I guess I just pointing out the analysis is probably mostly in that paragraph 192, where I don't consider there to be significant adverse effects on the environment because they're existing facilities. And then, but I do take your point for the fullness of the analysis that I can go away and think about that question.
And that also pulls in where Commissioner McMahon started, so that those existing activities could be extended with potentially material additional effects, or maybe there wouldn't be material, but they could certainly be extended given the breadth of the purpose of the designation.
Yes, correct. So I can think about that.
So leave that one with you to ponder.
Just before we leave education, Mr. Smeaton, and you may have answered this earlier, and I'll just check. The chair asked you about notations in the district plan relating to notable trees and heritage items and the like. And were you responding generically about all designations, or were you responding to just the, I think we were talking about Kiwi, talking about Chorus or First Gas at that time. Have you, for all of the designations, including education, looked at existing notations for heritage items or notable trees or flood extents or SNAs? And
certainly for any of the new designations,
right,
where a notice of requirement has been provided, I definitely looked at any notations for the rollover ones. Less so, but
why is that? Because I mean, you've already indicated to us that the existence of a submission isn't necessary to add in a new condition or add in a new requirement. So, and obviously, even for a rollover designation that's being proposed to be carried over, but didn't have conditions on it in the operative plan. Why would you not look at perhaps imposing those sort of conditions on the rollover designations, particularly where, for example, there's a heritage item and, you know, the designation would preclude the plan provisions relating to that being prevailing?
I wonder whether we should short-circuit that and ask Mr. Smeaton to consider that specific issue in his reply for the 71.
Yes. For the 71 of the 80, 70 of the 81 notices.
Basically all the rollover. Yeah. If there are any overlays that, in the same way as you've suggested for First Gas, you think it's important, like the nature of the overlay and the nature of the planning direction associated with the overlay, that it's important to capture that.
Yep. So that might have some implications for the requiring authorities. But I guess we're asking you to alert us to, well, two things: to alert us to the existence of those overlays from a heritage and hazard and natural feature perspective. But secondly, what your recommendation might be as to whether they should be captured in those 70. I can see how you've dealt with that differently, say, for example, with Chorus with the Te Tahi Bay Exchange, there's that Norfolk pine presumably is a listed tree, is it?
It is, yes.
Yes. I'll have some questions on that when we come to the appendix, unless it's you want me to raise those now. Mr. Chair?
I think we should we'll
Yeah.
hold that thought for the appendix. But I think as a general point, I think it would be prudent, and I think we need to know if there are overlays, particularly like for SNAs and which are overlays that are responding to Section 6 directions.
Yeah. So, for example, let's just, it goes back to that long discussion we had right at the beginning about the power of the designation. So, let's say, let's say there are a handful of notable trees or even a couple of heritage buildings on some of those 70 rolled over designations, and the requiring authority wants to remove the tree or the building. Does that require an outline plan? The designation would authorise the removal of the designation would override the rule that required a consent otherwise for the removal or demolition of the building or tree. What would the outline plan require, if anything? The reason I raise this question is I'm very familiar with what Christchurch City Council have done. They've included all notable trees and buildings as a condition of consent and made it clear that the designation does not authorise those. So if in effect that creates an envelope for the designation, the designation has power over everything other than that notable listing or SNA or whatever. And that was very intentional by Christchurch City Council. They did that, and local requiring authorities were very aware of what they were doing, and they made their cases known. But in this case, you haven't sought to recommend it initially. We're raising it as a possible question as to understand how extensive the interaction of the overlays and the designations are, and then as to what your recommendation might be in terms of including them.
Okay.
But just going back to my specific question, what do you think there would be a role for the outline plan in relation to a notable tree or a notable building, a listed building on let's say a telephone exchange site or a school site, where there's no mention of it in the designation or the conditions? And these designations will prevail for the next 10 to 20 years. They'll have a life after the current plan is reviewed in 10 to 15 years' time, and so they have an interim effect already, actually.
Correct. Yeah. So for your question of whether or not an outline plan would be required if there was, say, a notable tree on an existing designation,
Or even just a small building that's for some reason has heritage status.
Well, we'll give it. Let's have a site specific. You have a school. You have a notable tree in the corner of the playground.
Would the requiring authority be able to remove that tree as a right under the power of the designation, or would they require an outline plan?
Yeah, I'm just thinking whether that would be considered to be works.
Yep.
That would then require an outline plan.
Yes, I've just pulled up section 176 Cavalier.
I can
Commissioner
probably
McMahon has it clear in his mind as say an outline plan of the public work project or work to be constructed.
So if there's no construction,
No new construction.
then possibly not.
The tree might be causing a nuisance to a neighbour, or might be dangerous to students in the playground.
So yes, I think the answer, quite possibly, an outline plan would not be required in that instance. It would just fall under the works that are enabled by the designation.
Yep.
The
Even if an outline plan was required, would would this be applicable? I guess it's a recommendation then only, isn't it? Don't remove the tree.
Correct,
or,
yes.
Or remove it under these conditions.
Yes.
And is that appropriate? I guess that's the question we're asking for you to reflect on.
Yes, and yeah, I'll definitely provide an answer to that through right of reply. I guess, but my initial reaction is that all these rolled over designations, that is the right under the operative district plan.
Yes.
Currently.
Well, yes, but you already said, Mrs. Smeaton, that they don't benefit from clause 9.3, so the fair game. You've also said that we're not limited by submissions to impose further conditions. You've acknowledged that the planning period's wide, and that the designation is all empowering, and the outline plan has limitations and is reliant on goodwill from the requiring authority to accept recommendations. And if they don't, then the council then has to become the appellant.
Correct.
So all of those factors, I guess, need to be considered in terms of the intersection of plan features with designations and what your recommendation might be as to alternative or additional constraints on the designation.
Yep.
And it's not just limited to education, that's across the board.
Yes.
Yep.
All right, there's that. Shift to roads and the CMA. We have paragraph 226. You'll be aware, Mr. Speakman, that this issue is somewhat vexed as to where mean high water springs actually is and how it's described for the purposes of the district plan.
Yes.
So you've said somewhat boldly, if I might say so, the land is also within the CMA as defined by the line of mean high water springs. So the question for you is, how do we know where mean high water springs is? How do we define which bits of the designation are within PCC's jurisdiction and which bits are not?
Well, in that bold statement, I was referring to the area that Kotahi sought to include through their submission. More generally, where the boundary exactly lies would have to be defined through survey, I suppose. However, yeah, I guess there's the existing designation boundary, which uses the land boundary, the parcel boundaries, which I believe Mr. McDonnell has recommended be continued.
Yes, but Mr. McDonnell has also recommended a note in the plan effectively saying where mean high water springs is found on analysis or on survey to be seaward of the parcel boundary, the land is deemed to be zoned open space with an exception at the marine edge of Hongueka. That's the only exception. Does that? So I think that there's sufficient evidence before, not this hearing panel, but the previous streams, particularly stream 1, that the parcel boundary is, Mr. McDonnell's recommendation is the parcel boundary is the best boundary, but admits that there are exceptions where it does not coincide with the CMA boundary, and he's suggesting that be handled by a note to that effect, and there is at least one submission suggesting that for the same reason that it ought to be surveyed and the boundary ought to be shown on on the face of the plan. So in this context, clearly most of the bridge is within the CMA, but on the face of it, clearly not all of it, or possibly not all of it, and where the line between the two is unknown. So how do you reconcile that? How do you recommend that be addressed?
Well, I guess I go back to the fact that the notified designation in that area followed the existing designation boundary in the ODP, and this additional area to cover the bridge was sought through submission. So in my recommendation is to not accept that submission and to maintain the existing notified boundary. I think that's the extent that my recommendation can go in respect of this.
I suppose you could be fortified by the fact that Wakatahi agree with your recommendation, and with the suggestion that if it ever becomes relevant, they can survey it.
Yes, I think
Survey it and seek an amendment.
yes.
It's not really a question, but the part of your report that I've written, large notes in my margin about the overlap between designation and whether it's primary or secondary or varying, is at 239. I think you've said that these three designations are identified as primary in relation to the designation hierarchy. Where are they identified?
That's within the designation chapter itself, within each table underneath the designation heading. There is the table which one of those rows has.
You mean are currently identified?
Yes, within the PDP chapters. That, yeah.
Paragraph 250. I wonder if I could ask you to undertake the same exercise that you did for the former State Highway 1 conditions for those two, so we can actually see what you've accepted and what you've deleted.
Right.
We're talking about
That's a good idea.
to remove the conditions on those two former designations. And it may be as simple as just providing with your reply a copy of those designations, and like
Yes.
if having looked again at those conditions, the generic response that you've given us is perfectly adequate, then I'm happy you just give us a copy so we can eyeball conditions.
Yes.
Through you, Mr. Chair, would you suggest the colour coding exercise also?
I'd leave it to Mr. Smeaton's discretion, because if the answer is they're all construction conditions, then a note at the top saying that, and we can eyeball that and check it ourselves.
I mean, we found that exercise that you undertook for the state highway former designation very useful.
That's good.
Yeah.
The 253, you're saying, well, this is in relation to Porirua City designations. Designations are already in existence and they're not changing. Does Porirua own the land? Own or have an interest in the land? Same issue as with Ministry of Education. I suspect it probably does, but
Yes, I guess it's similar to you. I presume that there is an interest in the land for all the designations, but I could double check that.
I think that might be a good idea if you could check that. What's that? Yes, if you've got another one on Porirua, go ahead.
Yes, it's a more of a generic question, Mr. Smeaton. Do you happen to know what the difference between the number of designations that the council has in the operative plan and those that they've sought to be rolled over? Were there much that wasn't sought to be rolled over?
In terms of the Porirua City
Yeah.
Council designations, there were two that were not sought to be rolled over.
Yes.
I believe I've outlined that earlier in my report.
Yeah, I thought you had, but I just couldn't find it.
Yeah. So at paragraph 40,
And then try. Right, okay.
it's just under that table which sets out all of the designations.
Got it. Thank you. Now that's, yes, okay.
The going on to Spark.
Oh, sorry,
Sorry,
sir.
you go.
Okay, so, right. So the table, it's the paragraph under the table, isn't it? Not the table itself.
Correct.
Yes. Okay. And do you know the reason for that? That are those activities no longer in existence, or?
I believe one of them in the operative district plan, it had a note that said all local roads are deemed to be designated, and they were not spatially defined.
Yes.
So there was questions around that. So within the PDP, as the chair will remember, the infrastructure chapter has rules relating to roads, which
Yes.
sets out what can be done. So that addressed that issue, and I believe the other one was a decommissioning of
Of a reservoir? Yes. Okay, just on the roads one, that's always interested me. So the council are not relying on local roads being designated. There was rules that provide for roads as an activity in their own right.
Correct.
Okay. And where's that found? Just out of interest?
Within the infrastructure chapter. So there's a number of rules in there which relate to
Yes.
maintaining roads and then new roads as well.
Okay.
And within the standards, there are requirements around road widths
Yes.
and that sort of
So that'd be quite enabling provisions, I imagine.
thing. Yes.
Yes, and that's, I guess, that's a good example of where the designation tests would have shown that perhaps the designation is not necessary to meet the objectives of the requiring authority because there are other techniques available to do that. Not that we've got to that stage
Yeah.
with those two, but that could have been an example of that, presumably.
An example, yes, of a different method to achieve the
Yes.
outcome required.
Yes, and one of the, I know I asked you some extensive questions at the beginning, but generally in terms of the fall away of designations that haven't been rolled over for across all requiring authorities, have you provided anything in the plan on this, or have you not been able to capture that?
So you're asking if there's any other existing designations in the ODP that haven't been
Yes.
brought across. I believe it's only those two.
Only those two. Okay, that's interesting. Thank you.
Going on to Transpower, can you tell me what KO 801 is? Is that the substation at Pātahanui, or is it
It's a substation, yes.
the substation?
Apologies, I should have put that in the report.
Commissioner, got to the conditions. You had some questions. Why don't you do that now?
Thank you. Okay, I won't go over those clause 16 additions to the what is a designation. I think you're clear on that.
Yes.
Okay. On chorus, you've answered my questions on ancillary, so thank you for that. And that was basically relying on the definition of ancillary activity, wasn't it?
Yes.
Yes. Okay. I guess what I'm interested in light of the question I posed earlier about notable trees, etc. This chorus designation at Tatahi Bay is it's an existing facility, but a new designation.
Correct.
And you've added in three conditions, all dealing with the Norfolk pine. What's the effect of condition 3? What does that mean for the designation, bearing in mind the discussion we had earlier about the absence of notations on existing designations? Does that condition prevent the removal of the pine? Or
Yes, well, that was the intention of it. And I believe in my report, I noted that if removal of the pine was sought and it did not meet the requirements of that condition, then I believed that a Section 181 alteration of the designation would be an appropriate process.
Okay. So that's not condition 3 is not a outline, sorry, I'll rephrase that. Condition 3 is not a complete avoidance of the removal, is it? It sets up a process that the requiring authority, in this case, chorus, would need to go through to satisfy the council that the removal is appropriate.
Yes, so it's essentially taken from the standards which are included in the infrastructure chapter relating to notable trees and infrastructure.
Okay. Have you had any advice, taken any advice on the condition of the Norfolk pine on that site?
On the condition of the tree itself? No, I haven't.
Just bear in mind, I wasn't involved in the notable trees hearing. Does that schedule distinguish between notable tree types? Is there a hierarchy of it all implicit in the schedule, or is it just one schedule covering all trees? As compared to, say, differences in schedules dealing with category 1 buildings and category 2 buildings.
It's not my area. not one of the chapters I.
My recollection is that it's one schedule, but with details as to
Yeah.
of the characteristics of the tree in question.
Yep. I guess what I'm getting at, Mr. Smeaton, is whether that is the most appropriate condition, which sets up a process dealing with removal of the tree, or whether an alternative provisions which precludes the removal of the tree as part of the designation is more appropriate, which is more direct and more efficient and effective. I just wondered whether you might want to reflect on that in your reply. Because presumably condition 3, would condition 3 operate through an outline plan? Or not? Because, I mean, remember the discussion we had on construction of works necessitated?
I hadn't imagined it would work through an outline plan unless there was construction that was associated with the removal. If it was just removal of the tree with no associated works on the site,
It's just difficult to know what the mechanism is. Anyway, just reflect on those two different options. If necessary, have a look at what practices around the country. I've already directed you to Christchurch City in terms of the way they've dealt with some of these notable trees and other notations.
yes, yep, I can look at that.
Yeah. Okay, that was all for that requiring authority, sir.
Okay. I don't have any questions, so you just keep going.
Okay, the same question for now we're moving on to get my ducks in a row here. Seem to be missing a page. Here we go. First gas. We're moving on to first gas now. So you've suggested quite a extensive addition of conditions. Conditions 1, 2, 3, and 4. And they're largely all to do with construction, aren't they?
Yes.
Yep. So my first question relates to condition 1. Then this is the requirement to submit a CEMP, a Construction Environmental Management Plan, to the council with an outline plan. But my attention was really diverted to the word certification. And I wondered why you'd used that term, because it's a term that is often used in resource consents for certification of an outline plan as opposed to an approval of an outline plan, which is quite appropriate because you don't want conditions on a resource consent reserving a discretion. So that's right. But in this case, I think isn't the council required to approve or recommend on the outline plan?
Yes, I think you're right. I believe I've taken that wording from possibly other resource consent sort of conditions. So I think removal of that word for certification
Could be appropriate.
would be appropriate. Yes.
Yes. And just on that condition, Mr. Smeaton, and look, I think the condition's well crafted. We've got a requirement for a construction environmental plan. We know what the purpose of the plan is. We know what it contains, and that it must address the matters in 3 and 4. But it just seemed to me that there's a clause missing that no work shall commence until the plan has been approved. Is that implicit, or could it be more explicit in the conditions?
Yeah, I think it could be more explicit. Yes.
Okay. Okay. Sorry.
I was just going to say, I think it goes back to a question from the chair as well as to on those conditions for the works to be undertaken in accordance with the CEMP as well.
Right. Now on condition 2, you're going to replace that wording with the wording from the plan, I think.
Yes, and that's this is a matter which I addressed in my supplementary as well.
And is that, yes, and I read that, and what I got from that, Mr. Smeaton, was really that was allowing the condition to apply to all archaeological features that might be discovered, not just of a particular type.
Yeah, essentially, I made an error in this drafting in relation to that accidental discovery protocol, where actually I should have kept those conditions wording, which were suggested by or notified by First Gas, and then supplemented that with the Appendix 16 wording as a note, rather than deleting them as I had in here.
Okay, thank you for that. Condition 3, this is really, this is where obviously there is an SNA intersecting with the site, or with the linear extent of the designation. We know, and there may be more than one, presumably.
Yes, there is definitely more than one. I think there's 4 or 5.
Right. So this is the same issue that we've raised previously with the rollover of existing designations intersecting, in this case, with a natural feature. What's the purpose of condition 3? We know that an ecological assessment has to be prepared and submitted with the outline plan, presumably for approval of the outline plan. We know what it must include, and what adverse effects it must focus on, but what's the potential outcome of this? What is this condition seeking to achieve?
When I was drafting it, I was really seeking to achieve that if there are any adverse effects that are identified through the ecological assessment, that appropriate mitigation is put in place to mitigate, or, if appropriate, to offset.
Yes. Do you think the outline plan process is capable of undertaking that exercise? Putting aside that it's reliant on a recommendation back to the requiring authority, in this case, First Gas, and then the First Gas can choose to accept or reject, or accept in part that recommendation.
I think it is achievable through that process, where the requiring authority accepts the recommendation of the council and includes that information in the outline plan itself as to what actions are going to be undertaken for mitigation or offsetting. Then that would be a requirement on them to actually follow through with that.
Okay. The requirement is for them to produce a report that includes recommendations on the management of the works, and to identify any other adverse effects. There's no requirement on them to adopt that report, though, is there?
In part 2 of that condition, I had included a requirement for the recommendations of the ecological assessment to be incorporated into the CEMP.
As far as practicable. Yep. Required under condition 1 for the approval, for the recommended approval of the requirement of the local authority. Yep. Okay. What would be the alternative approach to condition 3 for where the First Gas proposed designation intersects with SNAs?
This is assuming that the designation is in place.
Yeah, if it's confirmed. Yeah. Or recommended to be accepted.
Well, I guess there are sort of a range of options where there is just no condition relating to significant natural areas, so that would enable any trimming removal of those of the indigenous vegetation within those areas, or to the other extreme, having a condition which did not allow that to occur or any process to go through to actually identify
But
mitigation.
quite a range.
Yeah.
Permissive through to preclusion, I guess.
Yes.
Okay. I guess what would be useful in your report back is if we could have a map delineating the intersection of the, or have you done that already?
There is one. It's not at a fantastic scale.
Which appendix is that?
It's actually within the report itself. So on page 22.
Oh, yes. Yeah. Okay.
And
Yeah.
on the opposing page in table 6, I've listed the SNAs that the designation intersects with and the area of the SNA as well.
Yeah. Is it possible to get some more, a bit more definitive planning, mapping on that?
Yes, absolutely. Yep.
Yeah. I mean, these questions that I'm raising may be jumping at shadows, but it'd be nice to know. I mean, obviously, the through Paha to Nui, and that seems to go right through into the SNA, doesn't it?
It does, yes.
And seems to straddle, well, parts of the one up north of Paikokariki Hill. I guess all I'm signaling is a similar approach to what we've asked you to do for existing designations, and show us the intersection.
Yep.
And explain what you think is the best course of action.
Okay.
Just a follow-up. As regards condition 3, reflecting our discussion as to when an outline plan is required, what happens if no outline plan is required?
Yes.
Can a condition require submission of an outline plan where section 176A wouldn't require it? And if so, does that suggest a need to reflect on how the condition is expressed?
I suppose in terms of just thinking about the activities which the designation actually enables to be undertaken, which relates to the maintenance and operation of that gas pipeline, any works which would require maintenance for any underground part of that pipeline would, I think, require an outline plan. Where it's part of an above ground structure, I think there would be less risk in relation to any significant natural area. So my initial reaction, at least, is that it's the wording of the good condition is probably formulated appropriately, but I can consider that further.
I know it's not a consideration for designations, but the risk of acting or not acting is something that we need to understand, and I guess there's two aspects to that. One is the extent of the interception of the designation with the SNA and how extensive that is. And secondly, the matter that you've just touched on, Mr. Meaton, that is where is the risk in terms of works with underground, probably less so, but above ground, who knows? It may be that it goes to access and the need to trim to create access, which in itself may not necessitate an outline plan. So,
How many more have you got, Commissioner? I was thinking I might have a cup of tea.
that's all on first gas, and that may be it, actually.
In that case, we'll take a break and come back to Mr. Smeaton and talk to him briefly about his supplementary statement.
Yes. Thank you.
Mr. Smeaton, talking about your supplementary statement, just a formal, a couple more on conditions.
Sorry, Mr. Smeaton. I thought I'd covered them all, but the NZTA ones had raised a few questions for me.
They're going to be in the supplementary.
Okay.
As well. But if you've marked those up, you deal with the substantive issues now.
Yes. I guess this is conditions 12, 13 and 15, and they all use the word maintain, those conditions. So in condition 12, NZTA shall maintain the following structures. NZ 13, maintain all landscaping, and then 15 shall maintain a permanent record. And I just wondered whether the word maintain has different meanings across those three. So, for example, in condition 15, maintain a permanent record is keep a permanent record, isn't it? And update it. Whereas 12 and 13, are you talking about, well, in 13, is that maintenance of all landscaping work? Is that what that's referring to? As opposed to in 12, shall maintain the following structures. Does that mean retain the structures or maintain them in good working condition? I'm just unclear as to the purpose of the wording under all three conditions.
My assumption was for the latter, but I should note that this wording is taken from the existing conditions.
Yes, and has the word maintain altered in your right of reply, your rebuttal evidence? Have you altered these conditions?
No, I have not changed.
No.
Recommended change.
Question's a little bit clumsy. I'm sorry about that. But do you see what I'm getting at? I just don't understand what the word maintain means in terms of, say, condition 12. Is it retain the structures? Or is it make sure that they're maintained in good working order? Or is it both?
Yeah, I do understand the question and the difference potentially in the understanding of what that word might mean for the different.
And the same with 13, with maintenance of the landscaping. I mean, presumably that's about similar about any dead or diseased trees shall be replaced, etc.
I suppose in specific to condition 13, it does specify maintenance shall include replacement of plants, so it's a bit more defined in that respect. But
well, what was the intent? What's the intention of 12 then? Is it to ensure that those A to G are kept in place?
I understood it to be what you're referring to previously in good working order. But again, I guess the wording itself, is taken from the Board of Inquiry recommendations on the designations.
Subtext. Go and ask Judge Dwyer.
I was involved in that.
Oh, you little devil.
Yeah.
So we know who to blame.
Declaration of conflict there. But when you're looking at conditions at the time, you don't always go into that level of detail. So it's always with the benefit of hindsight. Yeah, if you could reflect on that, Mr. Smeaton, that would be good. Condition 16 has a discretion where it talks about NZTA shall, to the satisfaction of the General Manager, Policy and Planning, undertake the following measures, which makes me a little bit nervous to have those aspects of a discretion in a condition. I wonder whether you could address that in your right of reply also.
I can, and I guess again the same statement in that wording was taken from the existing. So
Well, what I'm saying is two wrongs don't make a right.
Yep.
again, these are conditions that would be exercised through the outline plan, or are these prevailing? These are conditions that will endure, won't they?
Yes.
So that particular condition relates to Taupo Swamp. And the mitigation measures, aren't they?
Yes, and that's I'm moving towards my supplementary evidence, which
Yes.
I can speak to.
Like
later.
well, let's come back to that on that then. I'll just make sure that was everything on. Yes, it was. Thanks. Everything on Appendix A.
Ms. Smeaton, the only question I had about the text of your appendix, rather than the analysis of the conditions, is paragraph 21, or 20 and 21. As you note, clause 1813 requires the territorial authority's agreement. I know you're giving this evidence with the council's authority, but do you have authority to confirm that agreement?
I think I will actually have to provide that through write a reply. Yes, it's a good point, and I think I would not be in a position to provide that agreement
Yes, I
myself.
suspected your delegation didn't quite extend that far.
No.
Now, moving on to the analysis of the Wakatahi conditions, the first one is I wanted to ask about condition 2, using includes the words implementation of the works. And so the question for me is implementation an ongoing thing? What did the notice of requirement originally say? What was the nature of the works that are being implemented?
Yes, I did have a question around this particular condition, whether it should be, in my mind, as to whether it should be carried over or not. And I suppose I came to the conclusion that it didn't need to be, because the works have already been completed.
I suppose the question is, how were the works originally defined? Can we, we'll put it another way, are you sure there's nothing left to be implemented?
Well, I suppose there are still some actions within particular conditions which are to be undertaken, which relate to the timing with transmission gully. So whether they are included within the wider understanding of the works, or whether it's just confined to the physical works themselves, where I believe they have been completed, I could seek confirmation of that from our monitoring team, if you'd like comfort on that.
I think, can I ask you to confirm that? Because of course we have the Residents Association expressing concern that nothing slips between the cracks, because we think it's okay, but in the fullness of time there was something else. Similarly, condition 6, you said that you don't. This isn't required because discharge of stormwater would be a regional consenting matter, which is clearly correct. But do the conditions in the regional consent prevent discharge of floatable material?
I haven't viewed the regional consents themselves, so I'm not aware of what those conditions specifically state. So I'm not sure.
I think I should ask you to check that because if the regional conditions have generic stormwater conditions, then that might be something specific that this provides that they don't. I'd assume they have stormwater conditions because this seems to anticipate there will be stormwater discharges. It's managing what's in them. I wondered about your logic in condition 15. You're saying, well, condition 7A in the second designation covers it as modified because condition 15 talks about fulfill the intention of the conditions. Which seemed to me to be broader than just, well, we've got a plant that's died, it has to be replaced. Whereas that plant might have been a specific height for a specific purpose. It might be high, it might be low, it might be something in between. And the question is, do we know for sure that the landscaping does fulfil the intention of the conditions as it sits here and now?
Well, yeah, I suppose it comes back again to whether that landscape management plan has been provided and has been certified. So I was sort of more focused on the maintenance aspect of that condition 15.
I suppose that's a more general thing. I noted in a number of things where you said it's happened. Well, as a matter of fact, has every element in these conditions actually happened? The construction, every construction element, has it actually happened? Are they sitting there in good working order at present?
Well,
I understand that's an impossible question for you, but I think that if we're going to delete the question, if we're going to delete the conditions, we need to know the answer to that. We need to be, particularly given the concern expressed by the Residents Association, who, reading their written presentation, are telling us that it's been a mission.
yes, I think I could address that through right of reply. I might have to liaise with Waka Kotahi on providing detailed information on that, but
I get all the way to page 22 now. Condition 11 on lighting. Understand that the standard's superseded. Do we need a different condition with the new standard?
I think it might relate as well to Waka Kotahi's sort of standard maintenance of lighting for its state highways, whether that condition is needed or not. So I think it relates to that third criterion, which I had put into my supplementary as to whether there are any other matters that might necessitate something to be carried over or not, or whether it's addressed through other matters. So I think that's something, again, that I could probably look at and provide some information through my writer reply.
Please do. And page 38. Um, 52.2. Form, seal and maintain the car parking area. You said design and construction of parking no longer relevant, but surely the maintenance element is relevant.
Yes. I think that's correct. That's probably one that remains relevant.
More generally, reading the Residents Association submission or written comments this morning, they're suggesting that if you are going to select, that there is merit in retaining in some sort of schedule the previous set of conditions to know for clarification as to where these conditions have come from. What do you think about that?
I don't think that would be required within the plan itself. I think the Board of Inquiry decision should be reasonably readily available, but that might be arguable. So it might be better sitting on the council website somewhere as additional information for the preparation of the plan or similar.
Somewhere that is searchable.
Yes.
That was all I had for Mr. Smeaton. Commissioner, do you anything? Nothing further.
I guess maybe just to recap on the sort of homework we've set you, Mr. Smeaton. I guess in terms of the big picture, it's it's for those 70 designations that have been rolled over, and with some GIS assistance to see what the intersection of those are with scheduled features, hazards, notable features, heritage buildings, SNAs, that sort of thing, just to get a feel for the nature of the potential issue, and then a response from you as to what's the best way of dealing with that. Is it through conditions that effectively limit the application of the designation over those areas, which is the far right of the options that we talked about? Or is it through a conditional approach similar to condition 13 on proposed designation for first gas? Or is it somewhere in between? I'm assuming it's not or is it the do nothing option? So that's really what I'm particularly interested in, and the starting point is really, notwithstanding that there haven't been submissions, that these don't qualify under 9.3, and so therefore they're live for that sort of intervention if deemed to be appropriate.
Yep.
The parting shot from me, I was going to address this at the end of the hearing, but probably a good idea for you to think about it. We're conscious that reviewing 71 separate designations in terms of their geographical extent is quite a task. Think about how long you're going to need for it. We're open to giving you more time on reply. We're not going to be deliberating until the first week of August. So if you want more time, there is more time available.
Yes.
I'm aware of, as the Commissioner says, if you're going to enlist the GIS team, then Murphy's Law will arrive. They'll all be down with COVID at the point where you get to that point, you get to that stage.
Yes.
So think about that, and so so at the end of the hearing, you can give me some feedback, and I can make directions to cover it.
Yes. Thank you for the opportunity, and yes, I'll come back with sort of an estimated time frame.
Thank you. We have the first gas team. Ladies, thank you for waiting patiently. We're a little over time, but we're ready to hear from you.
Should be working. Kia ora koutou. It's a pleasure to be here today. Thank you for having us. I am Megan Steiner, and I am joined today by Nicola Hine, Land and Planning Advisor for First Gas. Ash.
So that was Nicola
Hine.
as in the tree, or Hine.
Hine. Yes, yeah. Not the tree.
Rhymes with pine.
Yeah, it does. Ash, do we have a slideshow? Thank you. So I'm assuming that my evidence can be taken as read.
Yes, you can.
Thank you. So my presentation will be short and sweet and will highlight the key points from my evidence. I am wanting to support and reinforce the recommendations of the reporting officer, and myself and Nicola are available to answer any questions the panel might have about First Gas's operations or the designation. I will begin by giving a bit of context about First Gas's operations and easements, and following that I will outline the need to ensure the network is designated, and I will finish up by discussing recommendations from Mr Smeaton's 42A report and the agreement that I have with those. Thank you, Ash. So the first gas transmission and distribution network is located within the North Island and delivers gas from production stations within Taranaki. Within the Porirua district, the network runs from the southern district boundary near Transmission Gully, heading northeast along the outskirts of Porirua City and through various land uses and zones until reaching the northern district boundary. The Greater Wellington Regional Policy Statement recognises the importance of infrastructure, including gas transmission and distribution pipelines, to enable communities to provide for their social, economic and cultural well-being. The maintenance and operation of the infrastructure is essential to ensure the safe, efficient and effective operation of the network, as well as ensuring the safety of the public, property and the environment. So easements over the pipeline have existed since the 1960s, and while they protect the presence of and access to the network, obviously they do not provide for the matters that the RMA needs to address. In these circumstances, the pipeline is still subject to the underlying zoning, which doesn't always provide for this regionally significant infrastructure. The inclusion of this designation will allow First Gas more flexibility and freedom to operate and maintain this regionally significant infrastructure. First Gas, as a requiring authority, are seeking designations across relevant territorial authorities. I consider this as an appropriate planning mechanism to ensure increased protection of the network and sustainable management of resources. The designation sought within Porirua includes the land 6 metres either side of the gas transmission pipeline, with the purpose being the ongoing operation and maintenance of the gas transmission network within the Porirua district, inclusive of above ground incidental equipment. Any other activities within the designation would require the written permission of First Gas. This will ensure the purpose and function of the designation is maintained. I do note that the designation will provide sufficient protection within the existing designation corridor only and from a district level only, and does not secure access for operations over private property. Consultation with landowners will continue to take place. So lastly, I wish to acknowledge the efforts of the Section 42A officer, Rory Smeaton, whose recommendations I am in agreement with. This includes the removal of Condition 1 and to include conditions for any outline plan to include a construction environmental management plan, reinstatement of the disturbed ground following any earthwork activities, an ecological assessment when proposed works will affect Indigenous vegetation, as well as the accidental discovery protocol conditions and notation as amended by Mr. Smeaton's supplementary evidence. The implementation of the designation for First Gas gives effect to Part 2 of the RMA by providing for the sustainable management of the existing infrastructure resource and through enabling people and communities to provide for their social, economic and cultural well-being, through the ongoing security and resilience of infrastructure, providing access to energy resources. Thank you all. Commissioners, do you have any questions?
I think we probably do. I don't know how much of the discussion between us and Mr. Smeaton you were present for. I didn't observe you coming in, but I can't quite place where in the discussion went. But the issue that my colleague Commissioner McMahon was talking to Mr. Smeaton about was how the kind of conditions that he has recommended operate in, or what's the mechanism by which those conditions bite? Is it through the outline plan process, or is it directly how they expressed? Do you have I don't know whether you heard that discussion, but the thrust of the question is in terms of the juxtaposition, as you say, between a regionally significant piece of infrastructure that the RPS recognises and a nationally significant piece of vegetation that the RPS also recognises, and which Section 6C requires whose protection Section 6C requires be recognised and provided for, and what it's how that's addressed. Now, I think that you've agreed with the substance of Mr. Smeaton's recommendation, but I'm interested in your views on the mechanisms by which that actually occurs. So that's a very open-ended question. You can give me a short answer, a long answer, or something in between.
I'll start with the in-between, and I'll just note that the NPS for urban development identifies the pipeline as nationally significant infrastructure.
Yes, fair point.
And yeah, I guess coming back in a roundabout sense, it would be a rare event that maintenance or operation works would take place within an SNA area. But I do think there is a place for that condition to potentially mitigate any potentially adverse effects of the SNA.
And my point about, is that placed through the outline plan, or is it alongside the outline plan as a direct obligation?
Yeah, so I will also note, one of the infrastructure standards which allows for trimming, pruning or removal of up to 20 square metres of Indigenous vegetation. In relation to infrastructure. So I guess that would act as a bit of a benchmark, say, for an outline plan process or an outline plan waiver. While there are no criteria for an outline plan waiver, there is guidance on quality planning website, which includes consideration of likely effects and also whether or not the activity would be permitted by the plan.
Mr. McMahon, did you have any questions?
Yeah. Can you just give us the reference in the NPSUD to the identification of pipelines as a nationally significant infrastructure?
I don't have it on me, I'm sorry.
Okay. Do you, is it by definition? Is it through policy? What's the mechanism in that NPS?
I'm pretty sure it's definition, but I could check and provide you with that.
Thank you. Okay, so this is a new designation, so it's not a rollover of an existing designation. So it's subject to the assessment under section 171 is subject to part 2, which brings the SNA into square focus, you'd agree? Okay. How do you see condition 3 working in practice?
Sorry, just to confirm, this is the
This is
condition
the significant
requiring-
natural area. Sorry, not condition, is it? Yes, condition 3, isn't it?
As recommended by Mr.
As,
Smith.
as recommended by Mr. Smeaton, yes.
I guess in practice, if there was to be any maintenance or operation works within a significant natural area that met the criteria for an outline plan to be submitted, this is the correct condition, isn't it? Is it?
Yes, yes, I'm just,
Yeah.
yes,
An ecological assessment and report with recommendations would need to be undertaken and implemented as best as practicable.
What if there are no works as such that don't trigger an outline plan, but there's a desire for whatever reason, such as access through overgrown bush or whatever, there's a desire by First Gas to trim or prune or remove some of the indigenous vegetation in one of the two SNAs that it goes through. What would be the situation then where there was no outline plan triggered?
Yeah, this may be a question for Nicola, but my understanding is that that would really be a case. The network is pretty well clear of bush and the likes. Nicola, did you want to add anything from a technical?
Yeah, I guess from a practical point of view, for the most part, most of our pipeline easements, which are 12 metres wide, are clear of vegetation, and there's actually a clause in the registered easements which allows for us in that landowner relationship to keep those clear. So for the most part, the majority is clear. I guess when it comes to those SNA areas, I'm mostly familiar with the Pawatanui Inlet, and so in terms of vegetation there, I think that's quite a different kettle of fish to what we're used to seeing in terms of trees and shrubs and things.
Yes,
That's quite a bespoke area.
Yes, it seems that the pipeline corridor runs through the middle of that SNA.
It's a salt marsh.
Yeah, we were just chatting about how practically works would be carried out there. It's an underground pipeline. You're going to have issues with water and all sorts of things there. So definitely any maintenance would not be carried out lightly in that area. But coming back to vegetation, I'm not overly familiar with the second, I guess for casual reference, SNA area. So in terms of the easement area, we have a planting guide. So if there was something to take, say we needed to excavate and carry out works, we would remove I guess, vegetation as required. There are certain species which are problematic to the pipeline in terms of the tree roots can affect the pipeline coating, which over time could lead to corrosion. Or sometimes the risk is falling trees if we have, say, a shallow pipeline, perfect storm situation, and a massive heavy tree falls on it. And that's the only time we look to remove.
Yes.
Yeah.
And I can understand how that would operate in relation to landowner agreements and easements. But in an SNA, which where the value of the SNA is dependent on the retention of the species, I'm not sure that would apply. I'm not, apart like you, I'm familiar with the Pahanui Inlet and that SNA, but I'm less familiar with the one north of Paikokariki Hill. It seems, and that's why we've asked Mr. Smeaton to do the GIS exercise. But I guess where my eye is drawn to is clause 2 of condition 3, where it says that the recommendations of the assessment must be incorporated as far as practicable into the CMP. So there's an element of discretion there to the requiring authority, to First Gas, as to how they're included in the CMP, and then there's another element of uncertainty, and that is to what extent is the CMP recommended for approval back from the council, and to what extent would the Rarakoring Authority then accept those recommendations? So those are the uncertainties that are in my mind through these two important Section 6 features. The alternatives are the ones I discussed with Mr. Smeaton, that is, do nothing, and through to trying to exclude the SNA from the designation. And I presume that latter course of action isn't one that's favoured by First Gas.
No, it's we're on board with doing the right thing by the SNA areas in terms of the ecological, I guess, response as well in terms of the
But
environment.
what if the right thing is to avoid the SNA altogether? And particularly in relation to Pahinui.
The only way we could avoid that is to put in new pipeline infrastructure
Outside,
elsewhere,
yes.
which would, being linear network infrastructure, would cause a multitude of issues elsewhere, I would expect, in terms of urban development areas.
Sure. These are the sort of options we need to explore in terms of their practicality and reasonableness.
And I recall similar conversations in the Greater Wellington Regional Council hearings is it's quite a debate, really.
Yes.
If you cannot avoid maintaining your asset where it is and you have the conflicting SNA area, what is the appropriate?
Yes.
Yeah.
Well, one of the things we're required to consider where, as the Chair indicated earlier, where you don't have a sufficient interest in the land, i.e. ownership, and where the effects are potentially significant, is alternative methods, routes to achieve the objectives. So in this case, the alternative that might want to be considered is a deviation of the designation line. But what I'm hearing from you is that that's something you wouldn't support.
The complication there is also, say, we don't wish to expose the pipeline unnecessarily. So if there's a maintenance issue, it is likely we need to get in there to ensure continuity of supply or manage any risk of rupture. So in the event where we're having to look at alternative options, to lay new pipelines, say, in this location, say, Pawatanui, it would be kilometres, and trying to find the appropriate location, acquire easements, all that kind of scenario. You're looking at a couple of years of project.
Yes. In terms of the notice under section 176 or 181, I can't remember, 171, that was submitted with the new designation. I mean, did you prepare that, Ms. Barrett?
I didn't.
No. Who prepared that?
That was Natalie Webb.
For First Gas?
Yes.
Yes. Is she an in-house or is she a consultant?
She's a consultant. I work with her at Beca.
Oh, okay, right. And through you both, I mean, I haven't looked at that, Mr. Chair. Presumably there was an assessment of alternatives given the existence of a matter of national importance. Do we know that? And how coarse or specific that assessment of alternatives of the route was?
Yeah, I know there was an assessment taking place. I'm just not sure the depth to which it was carried out.
I mean, the case law says that the assessment alternative doesn't need to be, what's the word? It needs to be more than cursory, I think is the wording, but it needs to relate to the magnitude of the impact. So where do we find that assessment?
On the website,
Yes.
They're all, I have gone looking for them. Well, I can't recall what this particular one said.
Okay. Right, well, it's a difficult one. Well, it's finely balanced. Okay.
Question, background question for me. Where the pipeline goes through the salt marsh, is that private land or public land?
I recall answering some questions on that with Porirua. It was gazetted land, but Rory, did you ever defend?
You can speak to it, if you can assist Mr. Smeaton, that was.
I believe that the majority of the land is administered by the Department of Conservation.
Yeah.
So it's public land. But as Ms. Hine has indicated, I requested some additional information relating to the easement that passed through that. So they provided that easement document, which is referred to in the gazettal of the land.
So there is an easement over the public land.
Correct.
Did the Minister lodge a submission in relation to this designation?
The Minister for Conservation, no.
I think you would have heard some of my questions to Mr. Smeaton about the specific wording of conditions 1, 2 and 3. Did you have any response to those, particularly in terms of replacing the word certification with approval? Did you hear those questions? I think you were in the room when this is in condition number 1.
Let me go back a step.
Yes, sorry.
Page 5. Page 5 of Appendix A.
The specific question the Commissioner asked Mr. Smeaton was if it was in an outline plan, was certification appropriate, given that an outline plan has to, is under the statute, under 176A, is approved, whether that language is appropriate. And so Mr. Smeaton tended to the view that perhaps it wasn't. It wasn't a certification matter, which of course is how you would frame a resource consent condition. But because it's in the outline plan, it should be approved. And so the question is whether you have a view on that question.
I would tend to agree with Mr. Smeaton. I guess from a consistency point of view, the term approval is more appropriate.
Okay, thank you for that. And my final question, also on condition 1, was I raised with Mr. Smeaton that maybe there should be an additional clause that's saying that no work shall commence until the CMP has been approved. Would you
I would
support
agree
that?
with that, yes.
Yes.
Yeah.
Thank you.
I think that's it from us, ladies.
All right.
Appreciate you. It's nice to see you in person rather than down the tube
Yeah.
this occasion.
Likewise. Thank you for your time.
Thank
Appreciate
you.
it.
And it will go green like that.
Gentlemen, having in some cases struggled up to the desk.
I was just frightened I was going to...
Indeed. Perhaps you'd care to introduce yourselves. We have your brief presentation that we've read, thank you. And we've had quite an extensive discussion with Mr. Smeaton about his recommendation in relation as it reflects your submission. So I think we're across the issues, but with that introduction, it's over to you.
Thank you. Morrison next. Just a little bit of back. Russell.
The background notes that we sent you included on page 1 and 2 our written statement are deliberately quite long because we considered important that you know a little about the histories of the designations concerned, particularly designation K0412. We would like to read those notes in full if you haven't already done so, but for the sake of brevity, and unless you would prefer otherwise, and so that I don't have to read it so much out at this stage, I've tried to summarise the main points into something a little bit briefer, which I have here. Are you happy that I
Absolutely.
brief? Yeah.
Just roll on.
Okay. Essentially, the major points are, one, the Residents Association has had significant involvement with these designations, particularly KO412, whose work objectives were to relieve existing congestion on the Parramatta-Plimmerton section of State Highway 1 coastal route during the interim period pending construction of the transmission gully route. The association had a significant influence on the formulation of the designation conditions, all of which were, in this case, were imposed by the Environment Court, which is perhaps a little unusual for most designations. Most conditions were specific to the designation, and many were unique. For instance, we don't know anywhere else in New Zealand where heavy vehicles are instructed to move into the centre lane when going through a township. Secondly, when we found out about the plans to amalgamate all the State Highway 1, now State Highway 59 designations, and do away with most of their conditions, we asked to meet with officers from Porirua City Council and Waka Kotahi. Although we haven't met with Porirua City Council, we eventually had 2 useful meetings with Waka Kotahi officers online over the last few weeks. From those meetings, we told Waka Kotahi that A, we preferred not to spend more time on trying to reach consensus about what should be regarded as irrelevant or not. B, we thought that removing the designation conditions at this time was unnecessary and would be unhelpful for the community and others consulting on the future of the road. And C, making changes to the designation at this stage would conflict with the requirements contained in the designation itself. These views were also conveyed to Mr. Smeaton, and we were surprised that neither Waka Kotahi nor Porirua City Council appeared to have mentioned our views on these matters to you before now. I think that probably, in a nutshell, gives you a bit of the background anyhow. So I'll now hand over to Tony to take you through the rest of our statement, if that's okay.
Absolutely.
I'll switch on the voice this time. Thank you. Okay, our arguments. We've said in our statement that we believe that all the conditions in 411 and 412 should be retained at this stage for 2 reasons, and I think basically there are 3 reasons. So I'll have to cover those in a bit more detail. What we're concerned about is loss of a lot of the conditions in 412 and 411 will actually lose the history and the context within the way the conditions were imposed by the Environment Court. And removing those conditions will remove the context, remove the history, and it will also remove it from transparency to the public. there's been quite a bit of turnover in minor esplanade, so the new people coming in rely on these designations to understand why the road is different from many parts of New Zealand. Take away the conditions and they've lost that context. What worried me was that when we spoke to Waka Kotahi, their point of view was, but we know what these conditions are and we have maintenance contracts in place with our contractors, and anybody who wants to know about them can obtain them. But you've got to know they exist in the first place. They're in-house documents. They can be changed at will. In fact, they probably will be, because they're moving to a different form of contract. And without that transparency, there's no public scrutiny. We believe, secondly, that it's not appropriate to make big changes when, at this stage, it's just the wrong timing. Within 3 to 9 months, Waka Kotahi will be consulting on the future of this stretch of road with a number of stakeholders. Parramatta Residents is one of those stakeholders. And without the access and knowledge of those conditions, and some of them are very detailed and special, there's a concern that it would be unhelpful to the consultation. I have to say that the majority of knowledge about this is contained in Russell's head and his notes. He's lived with this for the last 20 plus years.
I think you need to make sure he's kept in cotton wool.
I think you're right. It's a worry because the knowledge can be lost, and people will then say, well, what's wrong with having narrow footpaths and what's wrong with having substandard road corridor, and why have we got to put up with all this noise and vibration, and shouldn't we have special road surfaces? Well, yes, you should, and it's one of the designation conditions is a special road surface to reduce noise. Now, Mr. Smeaton did pick up that applies around the Airlie Road area for Whanatapu, but it also applies down Mana Esplanade itself, but that hasn't been picked up. And it would be very easy to forget that, ignore it, not include that. And there's a lot of conditions like that that are under maintenance that need to be transparent and need to be known by the public. I think the third thing I'd like to say is that people that consult the district plan for information, maybe for general interest or just because there's a specific item that they're concerned about and they want more information, the public place to go to is the district plan and the designation within it. Waka Kotahi say, but there are acts of parliament. They operate under various guidelines and they've got these contract procedures. The problem is they're not public to the point that the man in the street knows where to go. If you would expect to just consult the designation and all the information's there. But if we proceed with the proposed designation, most of the information isn't there. It's pleasing to see that Mr. Smeaton has picked up some very important conditions, but we believe strongly that that doesn't go far enough. And effectively what we would like to see is that the designation, it's the wrong time to change it. It should be kept as is, but updated to reflect the change to State Highway 59 and some of the changes to the boundaries, which are quite relevant. The other aspect is that there are still some errors within the update or the rollover designation, particularly notes number 2, where it talks about this section of road being a motorway, which in fact it's not. It's a local access highway. But that's detail. I think it's important that the current designations, which provide an important history and context for the required consultation, which is coming up this year or early next year, needs to be available to allow the proper knowledge and decisions to be made by those people consulting, and to allow the proper decisions and outcome to be achieved. So we can't see any compelling reason to remove those designations at this stage. We did say that a not so acceptable position would be that the rollover designation has the existing designations as an appendix, but, or at the very least, a strong paragraph identifying those original designations and where they are kept and a link to them. Because otherwise, over time, that information will be lost. I'm not sure whether I've covered everything. Without going into a lot of detail about the specific conditions that are really important, I think it suffices to say the whole designation is important. And just because some of those conditions have been enacted and are now in maintenance phase doesn't change the situation of the context and the history. So thank you. I'd like to ask any question. We'd be very happy to answer.
Yes. You were probably in transit, but we had a reasonably detailed discussion with Mr. Smeaton, fortified by having read, or in my case, having read your notes over my breakfast.
Good breakfast.
I think I understand your point of view. I don't actually have any questions about what you've told me. What I would like to ask you, though, is to give me some context of your position. Waka Kotahi are going to come and talk to they'll presumably talk to the council, and they'll talk to you, and they'll probably talk to anyone they can find about the future of the former State Highway 1. What's the association's preferred position on the status and future of that roadway?
Particularly Minor Esplanade.
Particularly Minor Esplanade. And the other piece of feedback that I can give you is that a former colleague and friend of mine, Jim Lynch, was on the first instance hearing panel on the Minor Esplanade Reserve, and he was voluble to me on the merits of the Environment Court's decision turning them over. But tell me, what's the association's preferred position? What are you going to pitch as part of that consultation? Do you even know yet?
We have a fairly clear view at this point, I think.
I suspected you might.
Yeah. I mean, essentially, since Transmission Gully opened, the amount of traffic going through Minor Esplanade has decreased to the extent that it's quite clearly unnecessary to have 4 lanes. So our position is that, preferred position is that Mana Esplanade reverts to 2 lanes with the standard amount of separation for turning and for lane widths. And the current clearway lanes are removed and go back to being what they used to be, which would be parking. And the clearways currently allow parking outside of clearway hours. And Waka Kotahi have to make practical provision for parking. And their practical provision is a white line. You're obviously aware that the road code says keep left unless overtaking or turning. That's what most people tend to do. They use the curbside lane, and so there is no parking. We're adamant that we want that parking back. And we want the separation from houses. We want a wider footpath to make it safer for pedestrians and multimodal forms of transport. Currently we know it's a substandard road corridor width. It was a compromise, and it was supposed to have been a short-term compromise, and it's been far too long. So it's a matter of fitting in that road corridor to the best advantage for motorists and for the public and for residents. Currently, that's not being achieved. Have I missed anything out?
You've asked.
I think Mr. Shaw's given me a clear fix because I lived in. Oh, sorry. Looking away from the microphone. I can recall life before the clear lanes. So I don't need any more background. I think that because it seems to me, in terms of the case you're advancing, Mr. Shaw, that given that's the position, the conditions you particularly want to keep and have front and centre are those that implement the clearway, that constrain the clearway and show what the clearway was trying to achieve, and so that it's to give you a platform to make your position that it's no longer required. So is that fair?
Well, you're talking about section 59, which is included in the rollover,
Yeah.
to a large extent. But there's other issues apart from that, such as the landscaping, fencing,
Yep.
what else?
Retention.
There.
There's a condition there. Yes, retention of views, and there's even the ones, for instance, that required Waka Kotahi or their predecessors to consult with the Parramatta and Plymouth and Residents Associations about what's the word? Encouraging the vehicles to use the left-hand lane. I mean, those consultations were held many years ago, but that in our view, for instance, is still relevant in terms of who, during this consultation period and during the making of the decisions should be consulted in or changing the designations. So, that's just in effect an example of where the context contained in those the existing designations, could have a role in the upcoming consultation period. I think I think it's also worth knowing that the Waka Kotahi has, or the Transit New Zealand in those days, made some very important commitments, including that they would, and this was in front of the Environment Court, that they would demolish the old Parramatta Bridge and remove the clearways in conjunction with the opening of the Transmission Gully. Now that commitment has actually, to date anyhow, has been dishonoured by the Waka Kotahi, and those are the sorts of issues that are going to come up in this consultation period. There are other suggestions that are likely to be made during the consultation period in relation to, for instance, putting a new footpath around Gear Point, where there is no footpath at the moment. About retaining the views that I've talked about at Gear Point as well. And what else are there? There's all sorts of possible things that will come up in terms of phasing of the lights, and parking restrictions or additional parking areas, and things like this will come up in the consultations and also in the negotiations with Waka Kotahi on the revocation of the state highway status and the negotiations there. So, there are a number of reasons why which people don't appreciate, why what they said in the original designations are still relevant. To be in, I see the situation pretty simply. I don't think that there is any need to make the changes at this stage. To be making changes to the designation now is premature and confuses the consultation, and in our view should, except perhaps for the updating of the state highway number to State Highway 59, and perhaps making some minor adjustments to the boundaries where necessary. Otherwise, it should be delayed until after the consultations have been held and the discussions for the future and the decisions for the future are made.
Thank you, Commissioner Mann. Any questions?
Yes, I have a couple, but I should just start by indicating that whilst I wasn't directly involved in the designations for the expressway, etc., I was very aware of what the commitments were when I was part of the Board of Inquiry on Transmission Gully. So Judge Dwyer presided over that, and you would have seen in that Transmission Gully decision some direct reference back to the Kapiti Expressway and Mana in particular. So that's just some background. In terms of your written statement, the conclusion where you've said our strong preference is that the original designations for 411 and 412 are retained in full and dealt with in the PDP at the stage. in the same way that the designation of transmission gully and Kenepuru link are concerned. Do you accept that as a panel we can't compel NZTA to carry over existing designations? That's something they've decided to do. They've decided to roll over the designation under certain parameters. We have some mandate over what those parameters are, i.e. conditions, but we cannot compel them to carry over a designation unless they wish to, and rightly or wrongly, they've decided to carry it over under certain parameters. Do you accept that our limited powers in that respect?
I'm not aware of them, but
Well, I certainly wouldn't have thought that you were limited.
Well, let me put it another way. When the council writes to requiring authorities, as they did before the plan was notified, they invite them to advise which designations they want carried over and under what conditions. And so that was undertaken. Mr. Smeaton talked about that process this morning. So NZTA, Kotahi, have done that in relation to this designation, and they've obviously volunteered some conditions and proposed to jettison some. So that's where we have the influence and the power to make a decision, not over the carryover of the entire designation. That's the prerogative of the requiring authority to do that. And I'm just inviting you to acknowledge that that's out of our hands. What we can control is the conditions that the designation that they've sought to roll over are subject to.
Probably not control. Influence might be a better way to put
Yes,
it, given that
influence.
we only have a power
yeah.
of recommendation back to Waka Kotahi.
That's a good point. Yes.
Yeah, but if they have identified conditions which they would like carried over, and you have influence on what conditions
Yes.
are being carried over, is there any reason why you can't
No,
say that you would like all the conditions?
not at all, so long as there's a good evidential basis for that. I'm just responding to your strong preference that the original designations be retained in full and dealt with in the plan, and that's something that we can't carry the entire designation over. We can recommend on the conditions that the designation is subject to, and that's really where that brings me to, and that is the devil is really in the detail, isn't it, in terms of the conditions that are proposed. I've been recording all the matters that you've raised with us, the clearway, the road condition and road surface for noise purposes, landscaping and fencing, view maintenance, consultation, those sort of things that you believe the conditions should replicate in terms of the existing designation.
Well, I mean, we could go through all of those
Yes.
conditions, but to be quite honest, all of them, in our view,
Okay.
have some relevance still.
Yes. Are you aware of the exercise that Mr. Smeaton undertook for the chair in terms of identifying? Yes, you are.
Yeah, we've got a copy of
Okay.
what he said. Yeah, but and of course it's not very easy for us to handle that sort of paperwork, shall we say? We don't have. Neither of us have the printers that print out in colour.
I understand.
And we don't want to have. We don't have the resources to print off 45 pages, and I anyhow don't have two what do you call them, computer screens, so that I can be referring to one or other at the same.
No,
time. So
it's difficult.
that's.
I didn't want to be critical. I didn't want to appear to be critical. I was just saying, trying to emphasise that, rightly or wrongly, the emphasis will be on the detailed conditions and comparing what should be in and what should be out. And what I'm hearing from you, for you both, Mr. Morrison and Mr. Shaw, is that you think all the conditions should be carried over and in total.
Yes.
I think that's a
Yep.
practical solution from our perspective.
Yes.
Wakakota, in our discussions with them, their clear approach was to go condition by condition and argue we've got this on an operating contract, so it doesn't need to be in there. To me, that's not relevant at all.
Okay.
And so they're approaching it obviously from, well, these conditions certainly haven't been enacted, they're not completed, and this maintenance is really necessary to be in the conditions. But the rest of it, I don't think they appreciated the historical context
Yes.
and the Environment Court's decisions and what it really means.
Yes. In terms of the lens that we should apply to this and determining what should be in and what should be out, acknowledging your position that it should, or everything should be carried over, are you'd want us to take note of your position that if a condition has an enduring component to it, such as a certain road surface to avoid, to limit noise from the road, then that should be carried over as a condition on the rolled over designation, as an example.
Yes,
Yes.
because without that being a transparent and public in writing in some publicly available document, how can anybody in the future say that road surface is not correct?
Right. Can you point us, and I'm not asking you now, but would it be possible to point us to an environmental outcome that sort of condition was seeking to achieve when the designation was first put in place?
With the road surface?
Yes.
It's all about noise and vibration.
Yes, and was there an environmental outcome in terms of a certain standard to be achieved at property boundaries?
Yeah.
In terms of noise level, yes.
Okay, right.
And of course, that's not within Waka Kotahi's rollover designation or Mr. Smeaton's
Okay.
additions.
Yes. Well, importantly, it's in front of us now, and
I think
it's
presumably the road surface was used as a proxy because it was assessed in the Environment Court that if you had that road surface, the end result would be a received noise at the neighbouring houses of X.
Absolutely, yeah.
But
There is a
so it was
requirement.
worked back from that.
There was a minus 3 dBs requirement, wasn't
Yeah, and that may well be, part of what comes out of the consultation. It will be that they need to be assessing
yes, and
the noise, and to do that, you need to know what the current what the conditions were at the time that those
Sure.
were made, and you need to know the context in which. And this is the problem. You're sort of we're sort of talking about individual maintenance requirements and things like that, whereas in fact the major reason for retaining, or a major reason for retaining those things, is simply to maintain the context that they were dealt with.
yes, no, I do understand that. I've had a lot of experience with roading designations. I understand exactly what you're saying, and that's why I wanted to particularly explore this noise matter. So, if there was a condition on the rolled over designation that specified a noise standard to be met at given positions and locations, how that is met, would you accept that? How that is met, as long as it is met, does it really matter if the designation specifies one possible way of achieving that, i.e. road surface, as opposed to another way of dealing with it through some sort of acoustic treatment adjacent to the highway? Is that a consideration that we should be considering, or is it more important to have the bottom line specified what the noise should be at the property boundary or given location?
There are other ways, things right through the set of designations there that have
Set of conditions.
The conditions, yes,
Yes.
sorry, which do have relevance to the question of noise, and
Yes.
and there are requirements for fences,
Yes.
and the design of those fences, and they even have criteria for landscaping.
Okay.
And there's also, of course, requirements for what's the word? Noise reducing glass and so on with in relation to the fronts of pretty
Oh,
much all
yes,
the
acoustic
houses along
treatment,
there.
yes, glazing, yes,
Within the
yes.
within the-
But all of those techniques, road surface, fencing, glazing, will all go to achieving a certain noise reduction at property boundaries, won't it?
Yes.
Yes, and that's the bottom line, really, isn't it? In terms of that particular effect, how it's achieved through that combination of mechanisms. Presumably, so long as it is achieved, does it really matter how it's achieved?
Well, I don't know, it may well be in the consultation
Yes.
that's coming up.
Yes.
That there will be preferences as to how it's achieved.
Yes.
So, you want to...
Should the conditions predetermine that, though? That's what I'm asking. Shouldn't they state the outcome to be achieved and leave the methods to be achieved up to that process that you've talked about?
Well, that may well come out of the consultations.
Okay. So on that basis, just to close that loop, it would be important in your view that the bottom line noise condition is maintained on the designation.
Well, yeah.
You don't want to take that out of, as an individual.
No, I'm just
Okay,
using it as an
because-
example.
Yeah,
Mr.
because there
Shaw.
are lots of other things,
Yeah, I'm
like-
sure there are. I'm just trying to focus on this as an example.
There's a condition, I can't remember which one number it is, but talks about if there are changes to the form of the road, it's to be consulted on.
Okay.
So changing lane widths or,
Okay.
because it was all about, the Environment Court was all about trying to keep the vibration, the noise,
Sure.
the odour, the fumes, etc.,
Yes.
away from residents and pedestrians.
Okay. Just thank you for that.
And the just concern is that we're in danger of losing all that context.
And I understand that. I think the term is death by 1,000 cuts.
Yeah.
Okay. What about, you made specific mention of some commitments that Waka Kotahi gave. I'm not sure whether the Environment Court decision or
Or the
proceedings.
The bridge?
Yeah, the demolition of the bridge at Parramatta. Was that matched by a condition?
No, but it was... well, there was no specific condition because, in fact, they also said that regardless of the conditions imposed, we will
Okay,
make these commitments.
sure.
Okay, so in fact, at the time, I was on the bench. In fact, in terms of not on the bench, I was representing the Parramatta Residents Association and Transmac. I did not consider being a layman. I did not consider that it was necessary to actually put those things into the conditions, because they had said publicly in front of the judge or the court, and it was also included in the heads of agreement, which I could read bits of to you if you like, heads of agreement signed by NZTA, or what were they in those? Transit New Zealand, Porirua City Council and the Wellington Regional Council, and in our view, and this is what we've been having arguments, if you like, with NZTA and the Porirua City Council about at the moment, that they are not observing either the commitment
Yes.
or the heads of agreement.
Okay. The reason I asked that question is that, and you've said no, it's not a condition, that limits our ability to give effect to your original submission, which is to carry over conditions. And if the condition doesn't exist, it really means that you're asking for, are you asking for a new condition to be added in respect to the demolition of the bridge? Or are you remaining silent on that matter?
No, not at the moment. No, we're not asking.
Okay. And what about for
Yeah,
the...
we are asking, certainly, for them, we have been asking for them to remove the clearways
Yes.
in conjunction or
Okay, that was my next question.
Yeah.
Yes.
Yes, removal of clearways in conjunction with the opening of Transmission Gully,
Yes.
which was a requirement, which they have not done.
Okay, again, was it a condition?
It wasn't specifically.
Okay.
Well, what it did, the situation was that section 59, which set out the things which needed to be consulted upon, included options relating to the future of the existing Parramatta Bridge, ownership and control of the work, the continuation of 4-laning St Andrews Road between Acheronrod and Jane Street, alteration of footpath widths, provision of arrangements for cyclists, other measures required to ensure an adequate level of service for the traffic volumes and traffic type, changes to the operation of the clearway or HOV
Yes.
lanes. All these things were supposed to have been consulted upon
Okay.
before
6 months before the opening of.
the opening
Yes.
of Transmission Gully.
I understand that now.
And for some reason, which I don't understand, the Board of Inquiry of which you were a part changed that. Now, we don't disagree with putting back the consultation, but we do disagree with putting back the need to close the clearways.
Sure.
Well, the Board of Inquiry didn't actually change it.
No.
What it did is come up with another one, which in fact didn't make any sense, I have to say, if you read it. And
Oh, don't be backwards about coming forward.
It was 10 years, it was 10 years ago.
yeah, and Wakakotahi have chosen to use their interpretation
Sure.
of that Board of Inquiry.
The importance of
condition.
having, importance of words in a condition.
Yes, I don't understand why the Board of Inquiry changed that.
Yes, I don't purport to talk on behalf of Judge Dwyer on
Okay.
that, so. Look, that's useful. I'm getting a clear picture of your position, and I don't have a clear answer as to the solution, but I'm sure that's something we'll discuss as a panel.
If we had the money to employ legal representation, I believe there would be Wakakotahi would be struggling to justify what they're doing at the moment.
Thank you.
We're just trying to protect the situation for the residents. You know, people have lived with this for a long time. And we don't want to see things pushed under the carpet, which is what I see is happening, especially before we've had a chance to negotiate.
Gentlemen, I wonder if you could just hold fire. Well, I just asked Mr. Smeaton a question. This discussion, Mr. Smeaton, has caused me to reference your table and existing condition 59 about consultation is expressed as prior to completion of construction of TG,
Yep.
which of course has already happened. How could that actually now be implemented? Like, it seems to me now to be an impossible condition. If it was imposed in the designation going forward, it would be impossible to comply with.
I believe the answer to that may be in relation to the interpretation of completion of construction. And while Transmission Gully has been opened for vehicles to pass over it, whether the resource consents and designations have all been fulfilled and therefore completion of construction has been met, I'm unsure.
Would it be prudent to be a little more precise as to what that meant? As I having driven over it this morning, it looks pretty complete.
Yeah, I think you're right in what you've picked up. in that to make any sense at all, it's got to now relate to the Board of Inquiry's decision.
Well,
I presume that within the designation conditions for transmission gully, there would be a completion of construction definition.
can we ask you to check that and
Okay.
advise us of how these interrelate?
Okay, I can do that.
I think there's some other wording which is relevant as well, and that is in fact in the Board of Inquiry's replacement, if you like, condition, and that's when I said before it didn't make any sense. In fact, it has the same problem. In fact, it talks about. Unfortunately, I haven't got the exact wording here. It talks about the opening of the completion of the work. No, the start of the work. That's right. And in fact, the start of the work was had already been undertaken by then.
Commissioner McMahon, any final questions for these gentlemen?
I guess the final question is what happens at the time that the revocation occurs, and whether you want to comment on that in terms of what that means for conditions.
Well, if revocation did occur and it became Porirua City Council's road, we would be negotiating with Porirua City Council.
Yes. And would you understand that the Porirua Council would take over that designation and the conditions associated with it?
No, I don't.
No, I didn't know that.
We don't. I mean,
I don't know if that's the case. I'm just posing that as a... Yeah.
Realistically, the Porirua City Council don't want to take over the State Highway 59 or State Highway 58 because of the costs involved in maintaining it.
Okay.
And Waka Kotahi have said they are happy to hold on to State Highway 59 at this stage. They want to retain their control over it. So realistically, there's that one anyhow. State Highway 59 will remain in Waka Kotahi's control. State Highway 58, they want Porirua City Council to take over, but Porirua City Council's present view, although they say they have no position at this stage on all of those matters included in 59, that condition 59, although they say that they certainly have indicated they don't want to have to look after State Highway 58 because of its almost continual maintenance requirements.
Okay, thank you for that answer.
And again, another substandard road. No footpath,
Yeah.
Too many issues.
You asked about the bridge as well. Our current view on that is because there is so much division, if you like, within the community, is that we have asked and have been ignored so far by, well, not ignored, but not much better than ignored, by Porirua City Council and Waka Kotahi. We've asked that they do some modelling of the effects of the old bridge on the harbour. It's believed by many that in fact the additional piles that going into the harbour entrance there are having an effect on the infilling of the harbour and speeding it up and reducing the flushing ability of the harbour. So we've said, although we're not, pushing for that to be demolished at this stage, we believe that before these consultations take place, they should have done some modelling so that so that so that it can the future of it can be discussed in an informed environment. So, I mean, that's one thing that it may well be during the negotiations, depending on what, if any, modelling they do, what will determine, what positions have been taken by various people on that.
Well, thank you, gentlemen, for your time. As I say, it's a pleasure to, like the first gas people who were in front of you, pleasure to see you in person.
Yes, it is. It's a pleasure to be here rather than Zooming, despite the hobbling along the road.
Yes, well, don't trip over on your way out.
No. Actually, the last... Not the last. That... Fingers crossed.
Thank you very much. We just have a few administrative things to clean up with Mr. Smeaton, but so Mrs.
Wondering. Look at what...
Well, like let's be specific about this, like, because the next topic of the discussion is the timetabling for Mr. Smeaton's reply. He's got a few things we've asked him to work on, which is going to take him a little while. I'm very conscious, having read your submission and the accompanying letter you wrote to the, I think it was the CEO, not the mayor, that the list of conditions you gave that Mr. Smeaton has analysed was what you described as, I think it was either an initial or a preliminary list. If I gave you, say, for instance, until the end of the week, the end of this week, would it be possible for you to eyeball that list and either add or subtract and give our hearing administrator an updated list of the things that you think are important to retain, accepting that your preferred position is we retain everything? If we're looking at a fallback position, if I gave you to the end of the week, say 1 o'clock on Friday afternoon, could you give us another list of, having thought about it some more, and also if next to each condition you could give us a one-liner explaining, if it's not obvious how this has a continuing role, if it's contextual, or if there's something more specific, if you could just give us a note explaining something that you might be aware of from the history, Mr. Morrison, but wouldn't be obvious to us. Is that possible?
Basically, we started going through that exercise with NZTA, and it became very obvious. I mean, they had 50-odd pages of things there, very similar to the stuff that you got from Mr. Smeaton, analysing each of these things, and it became very apparent that we would never reach consensus on that sort of...
I'm not looking for consensus. I'm asking for your pitch.
Yeah, but it's so much easier simply to include the whole lot, surely.
We understand that. I mean, rest assured, the chair wouldn't ask for this information if he didn't think it was important. We're not asking for an agreement. We're simply asking for you to tell us why certain conditions are particularly important.
But I suppose it's more, the thing I'm more interested in is not so much which ones you list, but why you list them.
Yeah.
Because there are some things that are clearly much more directly related to the consultation and the go forward than some things that are more general, but that we might not necessarily understand. Like and in a way, you've given us your pitch saying that we need the context, but by understanding how these individual conditions fit into the context, that assists us to understand why you're pitching for them all. And if we think that we can chisel a few of them off at the edges, we might do that. But it's our understanding. And so, like, I understand if it's too big a job and too detailed, and you don't have the facilities, then it's an offer. It's available to you. You can take it up or not at your option. And it's almost well, I'm happy to leave it on that basis. That if having reflected on it, you think you can provide us with a more detailed breakdown, you can have until 1 o'clock on Friday afternoon. And if you choose not to take that up, then just drop Ash an email saying you've reflected on, saying just that, you've reflected on it, you don't think you can assist further beyond what you've already told us. Are you happy to leave it on that sort of basis? It's over to you.
Love it.
Yeah.
Very happy to leave it on that basis. And I'll be issuing a minute in the next couple of days. I'll record that we've given you that option. But as I say, it's over to you. But we appreciate the amount of work you put into it already, and for you taking the time, in one case, to hobble in and come and talk to us in person.
Am I able to ask through you whether Mr. Smeaton, I mean, we sent you these similar comments to what we've made this morning, a week or so ago. And did you actually address the
Like, it's over to you, Mr. Smeaton. You can answer or not answer at your option. Like, there is a protocol that you can ask questions or clarifications through the chair, and I'm inviting Mr. Smeaton to provide a verbal answer, or he can reply in writing in due course.
I think I'd just like to reply through my right of reply, if that's okay.
Okay, no, that's fine.
That's great. Appreciate your time, gentlemen.
Okay, thank you.
Mr. Smeaton, the timing of your reply, as you just said, I've foreshadowed that I'll give the Residents Association leave until Friday to provide a further analysis if they feel able to do that. How much longer do you want for your reply? Accepting that the outer limit is probably, look at my days right. The outer limit is probably the 25th of July, which is a week before we are meeting to deliberate. You can have all of that time if you want to be conservative, or you can give me a bit less.
I guess I'll endeavour to get it done as quickly as I can. But maybe if we just put that date in, as you say, as the outer limit. But I'll endeavour to get it in. Can I just, sorry, I don't have a calendar in front of me. Is that
That's a Monday.
right? So I think I could, with as you've indicated, the Porirua Residents Association having an additional week, I think I could probably provide it to you within that 3 week period with an additional 2 weeks. But if we go with that 25th, then that would probably,
Okay, 25th, earlier if possible.
yes.
On that basis, I'll issue a minute in the next day or so, once I've got back to my base. I'll adjourn Stream 6 hearing for those further inputs.
Thank you.
Thank you all.